Hey, all persons attending before the Honorable Justice of the Appeals Court, now sitting in Boston, far and within the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is now open. Please be seated. Good morning, Your Honors.
Morning. Morning, everyone. My name is Vicki Henry, and I'm your panel chief today. Welcome to the December 16th, 2024 sitting of the Appeals Court. I'm delighted to be joined today on my right by Justice Desmond, and I should say if you would like to share your pronouns with us, you feel free. If you don't, then don't. Mine are she, her, and Judge Desmond uses he, him. And on my left, I have Justice Englander. We have 6 cases on for the morning. We'll probably take a mid-morning break after the third case. We have reviewed all of your materials, so I really, your 15 minutes, but we encourage you to jump to the heart of the matter. Also, I can tell you that this is a group of judges who have a lot of questions, so we will be taking advantage of the 15 minutes to get those questions answered. Sometimes you'll see us look at our iPads. That's because we try to be relatively paper-free, or at least 2/3 of us do, and on this panel. And so we're looking at your briefs, et cetera, when we're doing that. We are paying attention to you. We're just looking at the materials for your case. With that, I will call the first case this morning, which is 2023 P 1087, Commonwealth versus, and please correct me if I'm wrong, UCHE. And we will hear first from Attorney Howe.
Good morning, and may it please the court. Caroline Howe on behalf of Mr. Charles UCHE. There are 2 issues before the court today, and I would like to focus on the ineffective assistance of counsel claim first. Counsel here was ineffective because through his failure to act, he allowed the complainant to testify to a multitude of prejudicial and inflammatory uncharged conduct, which led the jury to convict Mr. UCHE on the basis of this alleged bad conduct. Bad act evidence came into the trial through unresponsive answers to defense counsel's cross-examination, and then these allegations were then repeated during the Commonwealth's redirect. And that included threats to leave the complainant dead or alive or as a corpse, that there was a restraining order against the defendant, and that he had been her middle school teacher and she did not report how their marriage was constituted. This was obviously a credibility case, and there was no extra evidence in the case pointing one way or another in terms of the he said, she said evidence, besides maybe an appliance that was on the floor. And so it certainly was not a reasonable strategy for defense counsel to be allowing this evidence to remain in the record.
So the Commonwealth argues that it was a strategic decision to bring out the tumultuous relationship between the victim and the defendant because it would demonstrate a motive for bias. What do you say to that?
I think that's absolutely true, but we know that defense counsel's strategy was not to allow this type of evidence in because he filed a motion in limine to exclude prior bad acts, which was allowed by the judge. And we know that he was not eliciting most of this very highly prejudicial testimony through his questions on cross-examination. And he told the judge during the sidebar between cross and redirect, I was trying to strike the evidence, even though he didn't.
But as I listened to the argument, as I read it, it just seems to me that I'm going a long way down the road to trying to figure out how this defense lawyer was going to accomplish what he was trying to accomplish without the difficulty that he had, right? And I mean, we're talking about incompetence here, right? Below the level of an ordinarily fallible lawyer, he decided he didn't want to try the case solely on what happened that day, that he wanted to bring out the relationship between the victim and his client, and it was really hard to control her. We've all been in that situation. That is ineffective assistance because he didn't control the witness properly?
No, I think it's ineffective assistance of counsel because he didn't move to strike her unresponsive answers, which is absolutely...
It's also a tactical decision. Please ignore the pink elephant that just walked through the room.
I think if the pink elephant isn't dominating the room, and I think that's what happened here on his cross-examination, is that there were so many prior bad acts that came in and then were repeated throughout the Commonwealth's redirect that there became a side trial, and this error was then compounded by his failure to request limiting instructions in prior bad acts.
Some of what you identify as prior bad acts he clearly made a strategic decision he was going to bring out. For example, the mistresses.
I think that's absolutely true. But again,
Are you saying his error was in bringing it out in the first place and making the decision to bring it out about the mistresses, or that his error was in not moving to strike something that he deliberately brought out?
So no, I think that the error is not that he chose strategically, and I think that it's obvious that it was a strategic call because he filed a motion to eliminate to specifically ask her about financial issues and affairs and other issues in the relationship. But it's about the order of magnitude, right? You have a restraining order, death threats. These were not things that he elicited. The allegations about grooming, this was not something that defense counsel got into.
There was nothing about grooming. I think, I have to say, having read the transcript, that, it seems to me, that's a tough sell, at least for this judge. She referenced the fact that she'd known him since he was her teacher in middle school.
And I think it was
I think
also...
she referenced it in order to say, I've known this man a long time and I love him. That's the way I read the transcript. But in any event, the death threats, is that really what it comes down to?
And the restraining order. I think that there was just simply so much prior bad act evidence that was very serious, that in a case where it's a he said, she said dilemma, and I think particularly where defense counsel, obviously it's her allegation of restraining order, the actual restraining order itself didn't come into evidence, but...
I'm not sure, are they death threats? You'll leave this place dead, or you'll leave this place alive or as a corpse, right? That's what she said more than once.
Right.
That's a death threat?
I think leaving a place as a corpse, yes, is a death threat.
Then there's a lot of discussion about what she meant by the word corpse, and she ties it up in the Nigerian language, and it doesn't sound much like a corpse anymore to me.
I think
Sounds like a rotten vegetable at one point.
I think that was, maybe she was trying to figure out her words when she was talking about the names that she said that she was called. But
You know what I'm talking about, though, right? I mean, there was an what do you mean by corpse? And then she's not talking about a dead body anymore.
Right, but she does repeat the word corpse, and I think for the jury, they could absolutely hear she's, going to be leaving the house as a corpse and interpret that very obviously as a death threat. And I think, again, the jury is going to interpret this evidence in the most natural light, which is as propensity evidence. And then we're invited to do so by the Commonwealth's closing, which, again, the defense counsel didn't object to.
Do you agree that this defense counsel filed a number of pretrial motions?
Yes, absolutely, to keep specifically this type of evidence out.
Object to a number of things and ask for sidebar?
There was a sidebar, I think, between the cross and the redirect. But, I think when you have this type of evidence coming in, it is your responsibility as defense counsel to strike, and it seems obvious from the record that he wanted to. And again, the judge had to explain to him, when you are objecting, you have to stand up and say the word objection.
Do you agree that failing to object is one of the weakest kinds of motions for ineffective assistance?
I think maybe moving to object, but here it was a failure to move to strike evidence that was, or testimony that came in as evidence. And there are cases like Sawyer and Peters where this court has held that counsel isn't effective for failing to move to strike evidence that is so detrimental to your case that it, just...
Do you, with respect to the grooming analysis, they indicated that she was a middle school student in Nigeria, which is their homeland. But didn't they date for a number of years after she had graduated, for 4 or 5 years before they became a couple or got married or whatever it was?
I don't think it's clear, but when she says, I didn't report how my marriage was constituted, I think that leads to an inference that their marriage was not constituted in a good way, and that they had...
I don't know.
Yeah, well, I think it's that suggestion.
Didn't they date for a while, 5 years after she graduated from school, something before they got married?
I think perhaps, but it also could be left open-ended. And I think that's that suggestion that is very distracting for the jury and that you just simply wouldn't want to remain in evidence as part of your strategy if you are engaging in this he said, she said credibility contest.
And you agree that she was a very difficult witness, not only for defense counsel, but for the Commonwealth, for the judge?
I think that's absolutely right, and that's why you use a motion to strike. If you can't control the witness, which this defense lawyer obviously couldn't.
The judge control the witness?
I think the judge was having to do what defense counsel is supposed to do, which is step in and say, please answer the question, or you're not being responsive. So defense counsel has a number of, ways of controlling a witness, and one of them is not letting her unresponsive, highly prejudicial testimony remain in evidence.
Do you agree that sometimes a counsel objecting and objecting and objecting can be off-putting to the jury?
Oh, I think absolutely. But again, this evidence is so prejudicial. It is so inflammatory that to leave it in evidence is ineffective.
So what's your best case on that?
I think I pointed to Salyer and Peters. I think those are examples where there was evidence that came in that defense counsel failed to move to strike, and that's at the heart of this ineffective assistance claim. I see I have 6 minutes left. I can turn to my Batson argument. So prospective jurors' express belief that the criminal system is unfair cannot be considered a race-neutral basis for a strike at step 2 of the Batson-Suarez analysis.
Let me ask you this question. Didn't he qualify why he felt the system was unfair by saying it's unfair, it's a money grab?
Yeah, I think he was saying...
So would you equate being a money grab as a race issue?
So I think what the Batson-Suarez analysis is getting at is...
No, answer my question.
Oh, yeah. I think it's a less obvious case here that what the juror himself was talking about was, I don't believe that the system is unfair because of my race. I think he was saying, I had a bad experience with the criminal system, therefore I believe the system is not fair but a money grab. But Batson... I
don't know that he said all that. He said, I don't think the system is fair, I think it's a money grab.
He said in his questionnaire, I believe I was misled and charged by the police and court.
Okay.
Don't believe it's a fair system but a money grab.
Right.
But the Batson-Suarez analysis is about, obviously, the prosecutor's adequacy and genuineness of the answer that they proffer as being race neutral. And so here, Suarez was very clear that the SJC was seeking to prevent the elimination of black jurors as a whole, as a class.
On the basis of their race.
Right. I think
Right?
that's absolutely
No,
true.
but that's... do you agree that the law is that what Batson and Suarez are about is striking someone on the basis of their race? Okay. So if somebody says, I don't believe the system is fair because I believe it's a money grab, or just leaves it as, I don't believe the system is fair, but they happen to be black, we then infer that they're saying it's unfair to me because I'm black? Why would we infer that?
No, I don't think that's the inference at all. I think what the Batson-Suarez analysis is concerned with is pretextual reasons given by the challenging attorney or the striking attorney.
One of the things it's concerned about, yeah.
Right, and so I
but
think
here we have a finding by the trial judge.
We do, but I'm challenging the adequacy of that finding, and also at step 2 that this is ever that this is ever a race-neutral reason. And I think Suarez got at black jurors are being struck not because of kind of pointless racism, but because of an assumption that based on how the criminal system treats them, that they are more likely to think the criminal system is unfair. And despite that belief, we still want them on the jury if they can be neutral in this case.
So that's a fair cross-section argument, right? It's not, to some degree, it's moving away from Batson, which says it has to be on the basis of race, to a different kind of concept. But there's no record here that in Massachusetts we have that issue, right?
I think
I mean, your citation, you've written a very interesting brief that cites Washington and California and legislation in California, I believe. But you don't have a record for a fair cross-section here. I mean, we had Suarez long before we had Batson, right?
Absolutely. I think what the SJC and the Supreme Court are protecting is the idea that even one juror would be struck on the basis of their group membership, right? So,
On the basis of their group membership, I agree.
Right.
So if you could write the standard you wanted to see us implement, it sounds like you're saying that a peremptory challenge could not be exercised because a juror thinks the system is unfair. Is that right, or is it unfair based on race?
No, I don't think the juror has to articulate that it's on the basis of race. I think it's that it's a pretext for eliminating that juror on the basis of their membership in that group. So yes, I think that's an accurate representation of my argument.
But that goes back to what Judge Englander was discussing, which is where's the connection between the juror's race and the statement is unfair, it's a money grab?
I think it's the idea that black jurors are being struck on the basis that they are being, the system treats them unfairly, they are more likely to hold this belief, and then as a group they're being eliminated from juries because of that belief. And we already constrain the use of peremptory challenges. They are not, freely used anymore.
So do we infer that when the juror explicitly tells us why he thinks the system's unfair? He told us why he thought the system was unfair. He said, I think it's unfair because it's a money grab.
And I think he also said it's unfair because of, his experiences in the system. But yes, because I think, again, it's about whether the proffered answer is actually race neutral, not necessarily about the juror having to say, because of my race, I believe the system is unfair.
Did the judge inquire of the Commonwealth whether or not they wanted to exercise a peremptory challenge on this juror?
I would have to check the record. I'm not entirely sure, but I think that I'm not sure why the Commonwealth exercised a peremptory here, but they did. I see that my time is almost expired.
Someone says, I don't believe the system is fair. How is that based on race?
Again, I think it's about whether it's being used as a pretext.
Can we agree if it's a white juror, it's not based on race?
So I think it's a different, you have to do the whole Batson-Suarez analysis, whether you can at step one establish that there's an inference of discriminatory purpose based on their membership in that group. At step two, that the reason is offered is pretextual.
But I mean,
right?
then it answers itself. A white juror is not a member of any protected group, so we're not worried about it. But a white juror says, I don't think the system is unfair. And they get, I don't think the system is fair. Mm-hmm. And they're struck. Mm-hmm. No issue with that. And by the way, it's race neutral, right? It has nothing to do with race.
Right, but I think Suarez is really concerned that through the use of peremptory challenges, it's possible to entirely eliminate a minority perspective on the jury in a way that it's not possible to do so for a majority. I see my time is up. If there are no further questions, thank you.
Thank you. We'll hear from the Commonwealth.
Good morning. May it please the court. Robert Reed on behalf of the Commonwealth. I'm joined here by ADA Jacqueline Martinelli. And I just want to go off of Justice Desmond's question about the reason that the prosecutor stated for their Batson-Suarez challenge. On page 91 to 92 of the record, the Commonwealth indicated that the reason for the preemptory challenge of prospective juror number 17 was because they, quote, believe he was misled and charged by the police, which was indicated on his questionnaire. And he also indicated that he did not believe the system was fair, but a money grab. The court credited that response on page 92 of the record. And although they did not use the words adequate and genuine, the court found that the Commonwealth's use of the preemptory was not based on the juror's prospective race or any other impermissible factors, and the trial judge also credited the Commonwealth's response.
So, counsel, when you have a black man who says, I don't think the system's fair, do you think somebody should ask him what the basis of that is, or is that related to his race?
I think that's a fair inquiry. I think in this case, the juror also indicated on their questionnaire that he was misled and charged in his own separate incident. That conversation and further inquiry was done in a voir dire with that witness prior to the preemptory strike being used. But I think that's a fair.
But nobody asked that question.
I think here, given the fact that the juror did indicate his prior experience, and that was also laid out by the prosecutor.
Well, okay, but let's step back, because we have both Chief Justice Gantz and our current Chief Justice Budd, who've indicated that this criminal system is unfair, sometimes in overtly racist ways. Do you agree with them about that?
I think that's a fair reading, but I think this case is unique because of the prospective jurors' actual question or
I want to be clear
answer.
about this because they said it, so of course it's a fair reading. Do you agree, or do you want to say your office agree, that sometimes the system is unfair in overtly racist ways?
I think that's I think that's fair.
Okay.
But I think that
So
this.
should somebody have made that connection? What do we do when, because a lot of people are afraid to talk about these issues. And so what do we do when nobody asks that question?
So I guess the court could have inquired more, but I think here where the juror explicitly stated that he believed the system was a money grab, I think that's different than him also stating that the system is blanketly unfair. I think using the words money grab in this context indicated why this individual juror would not be, or basically this was a permissible reason for the prosecutor to use a strike in this case, given the fact that he indicated specifically it was a money grab. And I think also, too, citing the reason that this specific juror was misled, in his words, and charged by the police, make it an adequate and genuine reason for the prosecutor to use a strike as a judge found in this case.
So here the juror says, I don't think that the system is fair. I believe I was duped when I had my interaction with the court several years ago, and I think it's a money grab. So given that he explicitly tells you why I don't think it's fair, is there an obligation then to ask him, well, why don't you think it's fair?
I think this was, I don't believe there's an obligation, Your Honor, but I do think that in this case, the juror's individual experience, as well as his familiarity and opinion of the criminal justice system, was laid out and stated on his juror questionnaire, but also articulated to the judge during the voir dire process as the jury was being seated. I think here...
Question on the record.
The questionnaire is not on the record, Your Honor. The judge did read into the record on page 62 that he was quoting the exact words that the juror wrote, which were, I believe I was misled and charged by the police and court. Don't believe a fair system, but a money grab. And that reason was also articulated by the Commonwealth on page 92 as their reason for the preemptory challenge. I do want to touch base on the ineffective assistance of counsel claim.
Before we get to that, so on page 29 of your brief, you acknowledge the defendant makes an argument that prohibiting peremptory strikes on the basis of race, but to allow them on the basis of opinions widely held by prospective black jurors is to misunderstand the purpose of Batson Soares. You acknowledge the defendant made that argument, but actually didn't see a response to that argument. So what is your response to that argument?
I'm sorry, would you repeat that question, Your Honor?
On page 29 of your brief, you recap the defendant's arguments, and you acknowledge that the defendant made an argument that, prohibiting peremptories based on race, but allowing them based on opinions widely held by prospective black jurors really undermines Batson Soares, I'm paraphrasing. Mm-hmm. And you repeat the argument, but I didn't actually see a response to the argument. So what's the response?
So I'm happy to supplement my brief, Your Honor. I guess I'm having a hard time articulating what that might be. I think as far as the response to why this prospective juror may be, I think this is an individual circumstance in this case. I think this juror was uniquely, based off their perspective of the criminal justice system, I think that the Commonwealth and the adequate and genuine prongs that are laid out in Batson Soares as well as Sanchez, I think they were met here. I think it has to be a case-by-case basis, an individual juror as they're being asked and potentially being considered for the jury. I think it has to be a case-by-case analysis.
So, because I've now been here 9 years this month, I've seen many of these challenges, and there does seem to be a concern on the part of many attorneys who argue for the Commonwealth in these trials to strike some, in fact, actually, it's in the jury questionnaire, we ask, we say, have you ever been prosecuted, have you been arrested? There seems to be this belief that if you've been in the system, you inherently can't be an impartial juror, and I don't quite understand that, because it seems to imply that if you've been charged, that you won't feel the system is fair. And does that concern you at all? That shouldn't at least some defendants think the system, even if they were guilty, they got a fair shake?
I think that would be a case-by-case basis. I would like to think that there are people out there who have been either arrested or charged and do think that the system ultimately worked out for them. I think that it has to be, the analysis though, and the inquiry has to be on an individual basis. I think that just a blanket statement of everyone who has been charged, obviously some situations and individual interactions with law enforcement officers go differently. So I think it really needs to be a case-by-case basis as it was here.
I should know the answer to this question, I apologize, but how many peremptories does the Commonwealth get?
We were allowed 2 each, and there were 2 exercised in this case.
District court, right? So
Yes.
2 peremptories.
Yes, and there were two used here. There was only 1 that was challenged on Batsosaurus grounds. And as I mentioned, I just as far as the ineffective assistance of counsel claim, this claim was not brought by a motion for a new trial with an affidavit. This was raised here on this appellate issue. I do think that the record is replete with references.
What more would we learn from a motion for new trial in this particular instance? I mean, the argument is that counsel did not handle this witness properly, basically, right? And allowed all kinds of prior bad acts to get in. It's quite evident from the record exactly what counsel was thinking, because counsel tried to file motions before to try to limit it, and then went in and did the cross-examination that was done. What more would we learn from a motion for new trial?
So I think as far as the strategic issue, I think an affidavit from counsel as well as potentially an evidentiary hearing where they might be allowed to indicate why they made those strategic decisions would be helpful here in this case. I think, as your honors mentioned previously, the best strategy or the best defense in this case was the bias of the victim and trying to bring that out. There was also an officer who testified indicating that they witnessed an air fryer basket that was the subject of the disagreement on the floor, as well as an overturned chair in the kitchen here. The defendant was on scene when the police arrived, made statements to the police as well. So I think that the best strategic defense here was to try to elicit the bias as well as a motive to lie of this alleged victim, who clearly had a tumultuous relationship with the defendant at this point. I also think that the defense counsel's representation did not fall below that of a measurably or an average infallible lawyer. I also think that...
So, counsel, what strategic purpose would there be to allow into evidence that she had a restraining order against him? Because that's usually a pretty big no-no.
I understand that. I think that the idea was that she had all these concerns and other issues going on in the relationship about how she was being treated by him, as well as some of his extramarital affairs and some of the course of the verbal altercations that the two had had. I think that while I
should have moved to strike the restraining order.
So
should have moved to strike, you'll leave alive or as a corpse, right?
So, Your Honor, the defense attorney did attempt to move to strike. On page 186, that motion to strike was overruled. The walking corpse was on page 183 when the alleged victim was asked what the Nigerian word was for walking corpse. The defense.
Oh, that came after. I mean, she made, or it came at a different time. That there was her statement. You'll leave. I can't remember what it is, alive or as a corpse. That was a non-responsive answer. It came kind of out of nowhere, right?
I think
and
that
you should have moved to strike it. Try to control it.
I think from the record, it's clear that the Commonwealth, the judge, and the defense attorney were all attempting to control the witness here. I think that the Ultimately, the way that the nature of the relationship evidence came in, I think that was all relevant to not only what led up to the altercation, but the most strategic defense for the defense attorney at this. I think all of that, while some of it she did seem to run on, I also would note that before, I guess, the Commonwealth's redirect, on page 175 of the first day of the transcript, the judge did find that she was rambling at times, but he didn't necessarily agree with the defense attorney's characterization that the evidence offered was so much inadmissible evidence, but more going to the nature of the relationship, which ultimately led up to the altercation on the 26th of August in 2022. I also just want to touch briefly on the Commonwealth's redirect of the alleged victim. The motion in limine related to prior bad acts was extensively litigated and ultimately denied at the beginning of trial. But after defendant's cross, in which there were multiple attempts to elicit information that the alleged victim...
denied, it was granted. The motion to limit prior bad acts was granted, but then the judge said, but if you're going to go down that road, decent chance you're going to open the door.
That's correct. So the Commonwealth also filed a motion to omit prior bad acts, which was ultimately denied. But your Honor is correct. After the cross of the alleged victim, the defendant was the judge did find that the Commonwealth could inquire more into the nature of the relationship. I do see that my time is up. If there are no more questions.
Thank you very much. Well argued. We understand. The case is submitted. Our second case on for today is 2023 P1415 Commonwealth versus DAQUAN A. Johnson.
Good morning. May it please the Court. Michael Locke for the Commonwealth. The motion judge here erred in determining that there was not probable cause to search the Acura. Here, officers responded to a shot spotter activation which indicated that 14 shots had been fired in the area of Alsace Street. When officers arrived, they saw parked in the middle of the road.
Counsel, can I pause you? So the judge says that the defendant was standing astride a door. So I just want to make sure we're all understanding. Does that mean he basically had one leg on either side of the door?
I don't know what the motion judge meant with that. I'm assuming he meant that the door was open, because if you've watched the body cam already, you can see that the Acura was in front of the Sonata. So the defendant would have been facing backwards, shooting at it. I'm assuming he means that by astride, he meant that he was on the other side of the open door, but I don't think there's any real evidence to support astride, one leg on the other side. No.
Okay. And are you challenging any factual findings as clearly erroneous?
I think there are several that are clearly erroneous. However, I think most of them, Your Honors, don't have to defer to Judge McDonough because most of it is documentary evidence. You can watch the body cam, particularly as to the size of the bag and whether a gun could be hidden in that bag or not. It's on the camera. There's a photo of it. This court doesn't have to defer to Judge McDonough's determination on that point.
Does the exception permit the Commonwealth or the police to search for evidence of the crime, or are they confined solely to the firearm?
Any evidence of the crime, Your Honor.
So any evidence of the crime, and there are cases that say that includes sometimes searching containers within the vehicle.
Correct, Your Honor.
And so if you have a shooter who is standing in a car that's running with the driver's side door open, who fires 14 shots and flees, And the witnesses are uncertain as to where the firearm went. Did he take it with him? Did he leave it? He threw the keys to his father, who was seemingly somewhat uncooperative as well. Why wouldn't you reasonably believe that you might find his license or ammo in one of those containers, in one of those bags?
I would agree with you, Your Honor. And I think particular note here is there were 14 shots. That means either it was a large capacity handgun, which means there was a lot of ammunition around there, or there might have been 2 firearms. So there's all kinds of evidence that could have possibly been found in that
It goes
car.
beyond that, right? You can search for evidence of motive.
Right, correct.
I mean, you need to, he's gone, so they may need to establish it was him so they can take fingerprints. Anyway, Judge McDonough's view appears to be that there wasn't probable cause because the only thing that you could look for was the handgun. And part of that, I think, comes from the way that the police are seen on the body cam, right? What do you say to that? That really the only thing they were searching for was the gun.
Probable cause is an objective measure, Your Honor. It doesn't matter what the officer said at the time.
What case would you cite for that?
I don't have one right off the top of my head, but I can...
Oh, because, you know, if a police officer says, the reason that I'm going to go do this search is X, and then it turns out that they do X times 10. Your position would be that doesn't matter as long as I can come up with an objective reason why they had probable cause to go beyond X, right?
Correct, Your Honor. Correct.
What case would you cite for that?
I don't have something off the top of my head, Your Honor. I think it's generally, that's the accepted, it's an objective test, whether there was probable cause at the time and whether a search
But I've
was-
never seen, I understand your point, I've never seen the situation we have here and that seemed to be troubling Judge McDonough, which is someone's gone beyond the scope of what they specifically have said is their purpose.
Right. And I think, again, I think it's an objective test. It's not a subjective test of the officers at the scene.
Doesn't Judge McDonough say he doesn't think the motor vehicle exception applies at all?
Yes, he said there was no probable cause. He initially finds that there was a protective sweep was proper, but then talks about how in the original decision he says there was probable cause, but the search exceeded probable cause or something. We filed a motion to reconsider, and he found that there was no probable cause to search the car at all.
Yeah, I think
So-
in doing so, he was applying the automobile exception. He was just saying, I find that the only probable cause was for this, right?
Right.
So, but if we take Commonwealth versus Moon, where the defendant's standing between 2 automobiles with a knife, not a gun, but the police figure out that one of the cars was registered to the defendant, and the Supreme Judicial Court said just because he arrived in a car doesn't mean you can search the car, right?
Yes, Your Honor.
Okay. So if, in this case, the defendant had a gun instead of a knife and the car's door had been closed and locked, would Commonwealth versus Moon mean that the police could not have searched the car?
No, Your Honor, because in Moon, there was no evidence that the defendant had just gotten out of the car like we have here. Here we have evidence from one of the victims who says he literally just got out of the car. The car was running when the officers arrived. The defendant's father stated that the defendant had thrown him the keys while he was fleeing. So there's actual evidence here that the defendant had just been in the car, which wasn't present in Moon. In Moon, it was just his vehicle. It was in the area. There was no evidence as to whether he had been in it recently.
And do you think that we are constrained because the officer may have misunderstood the law in saying, hey, we can go in there and we can look for the firearm?
No, I don't think so, Your Honor. Otherwise, officers would have to list off every single reason they could possibly ever get into anything ever before they participate in a search.
And it's fair to say that the judge, in the motion to reconsider, says explicitly, I determined that the automobile exception did not apply at all to the officer's warrantless search of the Acura interior because I found that after the officer's proper protective sweep of the Acura for weapons yielded no weapons or other contraband, probable cause did not exist to search any further.
That's correct, Your Honor. And I believe that determination is faulty.
Yeah, that's a very odd way to state.
If there are no additional questions, I'd ask the court to
Well,
reverse.
so the defendant argues, though, that the search of the bags was not supported by probable cause because really the reason to get in, you're saying, like, even if he had just gotten out of the car, shut and locked the car, and then started firing, Moon wouldn't apply, and you would search the car because he had just gotten out of the car, right?
Correct.
And that they could search for anything. It doesn't need limited to the firearm. They
Any
could,
evidence of the crime.
right. Okay. John, do you have any questions? No. Thank you. All right.
There's nothing further. I would rest on my brief.
I'm reading what Judge.
Good morning, Your Honors. Ashley Allen on behalf of the defendant appellee, Mr. DAQUAN Johnson. I'm going to start first with, I don't remember who asked it about the police officer's subjective versus objective intent. I think that the focus here should be the information that was known to them at the time. So I find it problematic that we're making an after-the-fact determination to list every single thing that could possibly have been found as evidence of the crime. The judge found that the object of this search was the firearm.
So what do we know on the officer's search? We know that the girlfriend and her sister had come back to retrieve her telephone, that they had called in advance that they were coming back, that when they arrived, the defendant was standing outside of his car. It appears, although I can't say for sure in my mind's eye, but it appears that he was standing in the doorway of the open driver's side door when he fired off 14 shots at them across the street and fled, threw the keys to his father, car running, and nobody knows what happened to him or the gun.
So just to clarify on the astride portion, he does also make in his findings that the witnesses said that he was standing by the Acura's door. I don't know if that makes any difference. It's at page 32. They did not see him exit the vehicle, which the Commonwealth does state in their brief. That was never the fact.
Fair
He's
inference.
outside the driver's door with the car running and has the keys.
I'm sorry, say that again?
But he's standing outside the driver's door with the car running, and he has the keys to the car.
Right, and I still don't think that at that point there's no evidence that the car was used in furtherance of the crime. No witness.
The car is running.
Right, and so.
He's standing there and shooting the gun. Do you agree with
Right,
that?
and so Moon, I think, applies in this case, where just because he arrived in the vehicle, and knife versus firearm, I think it's the exact same situation, just because he arrived in the vehicle doesn't mean that there's going to be evidence of the crime. We're not
It's not just that he arrived in
disputing.
the vehicle, it's that the car is running while he's shooting with the door open, and he flees, and the witnesses don't know whether he took the gun with him or not.
Right, and so if that's what gets reasonable suspicion to do a protective sweep of the vehicle, because the only possibility, and the judge said that it was not a great possibility, but it is possible, and that's where reasonable suspicion comes in, that he possibly tossed the firearm back into the car through the open
But
side
why,
door.
I don't understand this argument. I mean, I know why you're making it, but I really don't. The question is whether they had probable cause to search the car for evidence of the crime, right? That's the, am I stating
Right,
the
well,
automobile?
it's-
Okay,
yeah.
so the question is probable cause, not more likely than not, probable cause, something less than, quote, not a high bar. The crime is attempted murder. 14 shots fired into someone else's vehicle at close range. Why don't they have probable cause to search every inch of that car because it's reasonable to infer that the attempted murderer just left it before he attempted the murder?
Because the crime occurred outside of the vehicle. There's no evidence that he re-entered the vehicle after the crime. They knew who the person was. They spoke to his father. He tossed the keys to his father. The eyewitnesses had spoken to him.
Well,
on
you
the
say
phone.
they knew who the person
Identity.
was, but I'll tell you what, if you're defending this case at trial, you're going to say, hey, they have to prove that it was him who was the guy who fired the shots, and he's not there anymore. One way to prove it would be to prove that his fingerprints are all over the door, for example,
and
right?
I want to address the fingerprint and DNA stuff. So I think there were, the object of the search was the fire. I think that is a finding of the lower court. That was not challenged as clearly erroneous. So to now after the fact say, well, we're looking for all these other things. when
Well,
that
wait,
wasn't
say that again, because I think this is the nub of the problem. Say that, I missed it.
there was a finding from the lower court that the object of the search was the firearm.
But why are we bound by that, even assuming it's correct? your opponent says the subjective intent of the officers is not relevant. The question for us is, objectively, did they have probable cause to search where they searched, right?
Correct. And so, but.
Okay, so then why does their subjective intent even matter?
Well, because we need to, the automobile exception is limited. It's not this limit. I think that their reading of it is far too broad. That the first thing was a crime committed? We're not disputing that. Next is whether there was a nexus between the crime and the vehicle. I don't believe that they have that here. And on top of that, it's exceeded the scope of that. The object of the search needs to define the actual
What they had probable cause for, right?
Right, and where the object could be
And those cases
found.
are clear. In other words, you don't get to just search anywhere in the vehicle if you didn't have probable cause to search where you went. But here we're talking about attempted murder.
Right, and so I think that if we're getting into dangerous territories, if we're saying that in every single crime that we can now search for.
I didn't say that. And there are examples in the case law where you wouldn't say that the police officers would have probable cause to search anywhere in the vehicle. But here the crime is attempted murder, and he apparently used the vehicle to get to the scene where he fired from.
Right.
And we're supposed to use, like, common sense here, right?
But I also think that to then say that in every circumstance in which there's a shooting, we can now search for DNA and those cases where there's possession of firearm cases mostly, Guardado, Dame, and it was said in Garden too about how the object of the search defines where you can go. And if we're saying that in every single search, you can confirm their identity, you can search for fingerprints and DNA evidence, you can get into every single portion of that.
So I don't know if we're saying that about every single case. I know we're asking about this case. In this case, he's standing outside of the car in broad daylight on a public way with the engine running. He just fired 14 shots and fled. Nobody knows where the gun is. And he had the keys to the car. Didn't they discover his license in the car?
Yeah, in plain view, and that wasn't suppressed.
Don't the motor vehicle exception cases say contraband or fruits of the crime? Do they limit it to just a particular item? The exception.
No, but here that's what was determinative as the object of the search was the firearm. So and the police even said there's no evidentiary value to this vehicle.
Well,
So,
but
I
you know,
understand.
so they made a mistake.
So
So they didn't quite understand the scope of probable cause. Partly because we wind up in these kinds of discussions, which I think, and now I'm just expressing my own view, are a bit of a crazy way to construe what is a reasonable thing for the officers to do in the field under circumstances where there's a gun on the loose and somebody just attempted murder.
right, and so in those circumstances, they were permitted to look for that.
Well, not for
firearm.
their own personal safety, in order to determine who committed the crime, why, and where they might be.
And they had that information. They
They
knew
are
who
entitled to
committed
get
the
as much
crime.
information as they have probable cause to get.
Well, in this circumstance, they had the license was in plain view when they did their protective sweep. That wasn't suppressed. He had tossed the keys to his father. His father said, "Saw my son running." They had the eyewitnesses that saw him and the phone from father's girlfriend. So all of those things, yes, I understand that. Is there a limitless amount of information that could be determined from the vehicle? Of course there is. And that would apply in every case. But I think to say that in a shooting case, we can now go into every inch of a vehicle to determine a motive and to find fingerprints is problematic, and it contradicts the long line of cases that says that the automobile exception needs to be defined by the object of the search. And here, that was the firearm.
Do you agree that they could go and search for the firearm? I thought you were contesting that.
So I think that the lower court was right, that this is a protective sweep and completely within their bounds, even though it was unlikely that he tossed the firearm because nobody saw that. They saw him toss the keys to the father and saw him run, but once they weren't able to find a firearm on the scene, they were able to do a protective sweep of the vehicle. That doesn't mean that they have probable cause to search every inch of that vehicle. So one argument is I don't think they have probable cause to search the vehicle. And if they did have probable cause to search the vehicle, they exceeded that scope of the probable cause, because the two bags in which it was contraband that was found, it was a small Louis Vuitton bag in the front seat and a small zipper pocket. There's no way that he tossed the firearm into, one, it wouldn't have fit in there. He didn't have the opportunity to do so. And then the bag in the back seat, he had mere seconds in which he fled. There was no opportunity for him to get into the back seat, throw a firearm in there, and leave. And that's where Guardado and Cass both come in, because Guardado, they really focus on, did he have ample opportunity to secrete the firearm somewhere? So
But did they have probable cause to search for bullets?
I think that's the same argument with the DNA and fingerprints. We're still constrained by the
So you say
object of
no?
the search being the firearm, yes. Yeah. And so in Guardado.
What about
there
the
was-
phone?
I apologize, what?
What about the phone? Because he'd been in touch with one of the women by
Well, and
phone,
the phone-
by texting, I think.
And they had the phone of the sister, or I'm sorry,
They didn't have
the
his.
father's girlfriend.
They didn't have his phone with his fingerprints on it. Maybe that phone is sitting in the Louis Vuitton bag. That'd be pretty good evidence, wouldn't it? Might even have, like, the correspondence that led to him firing 14 shots into the car.
And if that's the way that this court's going to decide it, I have problems.
So I understand why you think I'm arguing with you, but I'm trying to understand the limits on what you're arguing. So why wouldn't a search for the phone have been appropriate in terms of probable cause to search for evidence of the crime?
Well, I think here, again, we're going back to, this is constrained to the firearm that they were looking for. That was the object,
That's because of
that was
what
the
they said was
instrumentality.
the object of the search.
Well, and that was the instrumentality of the crime. So does the phone have some relevance because there was a conversation beforehand? Yes, but they also had.
But the rule, as I understand it, I read them this morning, it says that the automobile exception applies to where you have probable cause to search for evidence of the crime that you're investigating. So why are you now saying it's limited to the object?
Well, because the object defines
or
the
instrumentality of the crime? That's the argument, and that's, I think, what the judge limited the search to. But why? Why? How is that consistent with the case law?
I'm not sure I have a good answer for that. I mean, our position is that this was limited to the firearm, and that's what they were looking for.
What's your best case for that?
It's the line of cases that when there's somebody who's armed.
What's your best case?
I would say Guardado, Cass, Dame, as well as Garden, where they're limiting the search to what they're looking for, which is in 3 out of 4 of those cases, it's a firearm. They're not looking for the bullets that go with the firearm. They're not looking for the DNA and the cell phone of the person.
So let me ask you this question. Let's assume for the sake of discussion that they are allowed to look for fruits of the crime and other contraband. And yet the officer mistakenly believes that they can only search for the firearm. Are they then limited to only search for the firearm?
I mean, I guess it's not really so in this
That calls for a
circumstance.
yes or no, if you can.
In this circumstance, under these facts, I think that we are restrained to the firearm.
My question's not that question.
Right, but these cases
You
are
don't
so
like my
fact
question?
specific,
You don't
you
like
know,
my
that
question?
if you gave me a different fact pattern, I'd be able to answer that as
My fact pattern really is leaving the facts aside. Let's just say that the officers are permitted to search the vehicle for fruits of the crime and other contraband, yet the officer believes that they can only search for the object of the crime, whatever it was, whether it was a firearm or whatever it was. Are they limited to that?
No, well, I don't think that the officer's misinterpretation of case law is relevant. But that goes to, like, the Guardado case is so important here because they're saying, what information do we know prior to the search? And they didn't know where he had been, where he had put the firearm. We know that he was outside the vehicle. It was impossible for him to have put it in the back seat. It was impossible for him to put it in this tiny zipper pocket that wouldn't have contained a firearm.
Why was it impossible for him to, I get your argument about why it was impossible for him to put it inside a container. If he put it in the car, he tossed it. But why was it impossible for him to toss it into the back seat?
Well, because what we're challenging is it was a Costco bag inside of a backpack in the back seat.
Got
So
it,
there was no
okay.
way for him to have gotten in the Costco bag inside of a backpack in the back seat. And nobody saw him re-enter the vehicle, or at most he would have been, from a distance, tossing it into the vehicle, tossing his keys and running. And mind you, this was mere seconds between the last shot being fired and the flee. No opportunity, unlike Guardado, where he had 1 hour, and Casper, there was a 6-hour difference in time between the report and the police searching the vehicle.
I'm not sure I'm hearing you correctly when I'm hearing CASS, C-A-S-S, but I don't think
No,
that's what
it's
you're.
CAST, 1990 case SJC, C-A-S-T. Sorry, I'm getting over a little cold.
What's the site for that? Because I'm not seeing it in your table of authorities.
I believe it's cited by Guardado.
Okay.
In talking about the ample opportunity and why they were able to get into the glove compartment versus where the informant had told them they would locate a firearm.
And so how did you say you spell that?
C-A-S-T.
CAST, okay.
I see that I'm out of time. If there are no further questions, I would rest on my brief and urge this court to affirm the order of suppression.
Okay.
Thank you.
Thank you very much. We understand, and the case is submitted. Our third case this morning is 2024 P526, Commonwealth versus Kevin J. Porter.
May it please the court, Catherine Sullivan Ledwidge on behalf of Mr. Porter. In this case, the prosecutor and then the judge, in specifying the condition of filing count 2 as a prohibition on crimes similar to assault and battery, dangerous weapon causing serious bodily injury, and not, for example, any violent offense or any assaultive offense, did not provide notice that offenses that are plainly lesser than an assault and battery, dangerous weapon, serious bodily injury resulting would constitute a violation of the condition triggering removal from the file.
So your issue at bottom is that he needed to have committed serious bodily injury or caused serious bodily injury for an offense to qualify as similar?
That would be one of them, but also the subsequent conduct in New Hampshire, there was no battery involved, and no bodily injury at all, not amounting to serious.
So for it to be similar, some bodily injury had to have taken place, at a minimum.
I would say at a minimum, but serious bodily injury, but also in
Well, at a
Billerica,
minimum,
And here, the offense for which he was on probation was that he had got into a fist fight with a homeowner and then went back to his car, retrieved a knife, and came back and stabbed him, right? That's the offense
well,
that he was on probation.
he didn't go back to a car, but he
He went to
he was heading out. He was heading out of the driveway when
threw some stones at him.
the
some
decedent
gravel.
threw stones, and then he turned around. So he would have been armed with a knife.
Okay.
Okay.
And in the case in New Hampshire, he gets into an altercation with the two women, and he kicks down their locked door and raises his shirt and shows the knife tucked into his waist.
Yep. And then in Billerica.
well, let's
Punches
stick
the
on,
guy.
let's
Stick
stick on
to
New
New
Hampshire
Hampshire?
for a second.
Sure.
That's an assault.
That's an assault.
right?
I concede it's an assault.
And it's assault with a deadly weapon. Just no serious bodily injury.
And no contact, no battery,
Right, it's an assault, not a battery.
just an assault, deadly weapon.
Okay,
Sure.
and now you're going to move forward to Bill Ricca?
I'm going to Bill Ricca, and it's an assault and battery. No dangerous weapon, no
Causing
serious,
serious bodily injury.
no serious bodily injury. No.
Having a guy on the, and we're not talking about a hockey game, having a guy on the floor and continuing to punch them as they're on the floor, causing blood on the face, no serious bodily injury, doesn't
No.
qualify.
No serious bodily injury, no.
know what the nature
It was
of the injuries
conceded
were?
by, I'm sorry, it was conceded by the prosecutor that there was no serious bodily injury.
Do we know what the nature of the injuries were?
They're shown on photographs in the record appendix, a busted lip. Blood, busted lip. It's shown, he lifts his face. The prosecutor conceded at the hearing that it was no serious bodily injury involved in any of the,
What's our standard of review? The judge found that these were similar.
I would say it's de novo because it's a probation condition, and it's,
Well, I think you mean it's analogous to a probation condition, right?
yeah, exactly.
You want to treat the two the same. In your view, the law with respect to revocation of probation should be identical to removing from a file in terms of how you determine whether the condition was violated.
Yes, I would analogize it to probation condition, which is what the cases do. Simmons and, sure.
I'm sorry, is the argument that both cases together satisfy the violation, or looking at either one of those new cases, the New Hampshire or the Bill Ricca case standing alone satisfies the violation?
I mean, I don't think neither does. I don't think it would matter if,
Commonwealth's argument that the two cases coupled together satisfy the violation, or either one of them independently satisfies. Maybe it's a better question for the Commonwealth.
I think so only because I don't think it was presented in that way. I think it was look at this and look at this. So maybe they were saying it in combination. I don't think it
Can you
matters.
shed some light on the timing, though? So he's told, don't commit a similar crime, and then New Hampshire happens, and do we know if the Commonwealth knows what happened in New Hampshire? And then he's incarcerated in Bill Ricca, and then it happens again. Like,
Yep.
in other words, what I'm wondering is whether there was some effort after New Hampshire, or whether that was just let go and he might be left thinking, oh, well, this was fine.
I don't know that happened. He was, there was an incident, so he was already, when he was in New Hampshire, he was, something happened in, I'm not exactly sure, in another town in Massachusetts before he went to New Hampshire, where he entered a house and he was going to kill himself. So the individuals there wanted, called the police to get him out. The police got him out. And then he went to a psych hospital and then he went to New Hampshire. All of that happened, and they had a violation warrant out. They didn't send him back because then COVID happened, and so they knew where he was, because the police, if you looked at the New Hampshire police reports and everything, they knew, they had just gotten a call about him. I can't think of the name of the town, of where this entrance, it's convoluted, but he then was going to be sent back, but then they held him forever, and they didn't bring him back.
Was he also on probation?
Yes, so he was, that's the whole thing. It's very, he was on probation for 5 years. And when they did the plea hearing in 2011, it seems that the prosecutor hadn't really thought about count 2. Because when she's asked, at least when you're reading it, it almost sounds like she's making it up as she goes. It wasn't, that's how I read it.
Yeah, I'm sorry. I'm reminded now. He was on probation, but then he won an argument that the
Yeah, that
count
they were
for which
duplicative.
probation had been imposed was duplicative, and so the probation was revoked, right?
So then right, so then they vacated, so Judge Frizan was presented with 2 motions at the same time. The defendant's motion to vacate count 3.
All right.
Because it was duplicative of count 2, and then after that happened, the Commonwealth said, well, if you're going to do that, then we're going to pull count 2 out of file
And
based on the
sentence him on
same
that.
reasons that we were going to
would've had it
violate
revi-
probation.
Yeah, got
And
it.
then in the end, Judge Pierce at the sentencing hearing said, well, it really doesn't all matter to me. It's still going to be treated the same, and it's a violation of probation, so.
So the Commonwealth argues, it's similar enough that the defendant cannot continue to threaten people with a knife. Why are they wrong about that?
Well, I think we have to look at the language of what was said. And I would just, I'm going to argue that it's just, it's the notice that was given to him, it's really confusing, unclear language that I think most people would agree it evokes some more serious, almost a manslaughter, which was committed, and not something lesser. That's my argument, is a notice argument, and it didn't rise to that level.
Did that happen at the same time he was being sentenced for the manslaughter?
Yep. Right. And the judge was, if you read the plea transcript, the judge was furious with the Commonwealth because they changed the higher end. It was supposed to be a 9:15 on one day. That they come in the next day. The Judge Haggerty expects it to be a 9:15, but in the meantime, they agreed to 9 to 12. And so it seemed like a very unpleasant plea hearing, and I don't think DA Ryan thought completely about the filing of count 2. That's my impression. And so when she was asked, she's like, well, he can't commit a similar offense, and she's like, similar to what? And then she says the count he's charged with, ABDW SBI. So it evokes a more serious crime, I would argue, notice-wise.
Do you think that's similar, and you may have already answered this question, you may have just answered this question, but do you think that's similar to an assault and battery with serious bodily injury? You don't think that that's specific enough? Is that right? Like, what more could they have said, similar to assault and battery with serious bodily injury?
What should she have said?
Well,
Any assault
yeah.
of offense, any assault. If he commits an assault,
Well, maybe that wasn't the condition. Maybe the condition wasn't any assault.
right,
It
and
was-
that's my point. It's not any assault. It has to be a higher level assault.
Right, but you're saying that's confusing. What's confusing about that?
Well, what I think then becomes how, I don't think it's confusing. I think it has to be a higher level assault. But what I'm saying is,
Is a higher level assault an assault with a dangerous weapon?
I think when she uses the highest level of the assault and battery statute, then I think it has to be, at least it has to be, I don't know, the way she words it, to me, it has to be that.
So I was going to ask that exact question. So your position is it had to be an assault and battery with a dangerous weapon causing serious bodily injury. Nothing short of that would satisfy taking this out of file.
To me, that's what she said.
So that's the same, not similar, right?
Yeah.
Yeah, but I think that's her problem when she uses the highest level. I think she's narrowing herself to that. That is my argument. And so these assaults without that just don't rise to the level. And
Well,
We
is
all-
there
we
any,
all- I'm sorry.
is there anything, I'm now Googling the definition of similar.
Yeah, I do that. I did that. I said
Okay.
it's, I have that in my brief, what's similar.
Well, I mean, so it's resembling without being identical. So what would resemble this without being identical?
Okay, so I would say it'd have to be definitely a battery, definitely a dangerous weapon, or causing serious bodily injury. There's got to be one of the, it's got to be something. So either the dangerous weapon, which makes it more, and then the SBI, you know what I mean? And a battery with the SBI. So something that makes it higher level than just an assault or an assault and battery.
An assault dangerous weapon doesn't quite get there.
No, because there's no
Do you
injury.
agree that, so similar may not be clear. I get your argument that similar's not clear, but we know it's not the same.
No, but it has to be some aggravation to it. I guess that's a better way to put it. If there are no further questions, I'll rest on my brief. Thank you.
Well, just,
Go ahead.
he can't think he can keep hitting people, right?
Right, and so the idea was, right, she should have just said assault or assaultive conduct. She
They
didn't.
really should have just said any crime
Sure, yeah.
to protect
Yeah, or she
society.
could have put it on
but
probation.
They didn't.
Why didn't they just put both of them on probation, right?
Right.
Right.
Carrying a dangerous weapon, not enough. I mean,
Nope,
That's what got him in trouble the first time, right?
yep. Thank you.
Good morning, Your Honors. If I may please the Court, Timothy Ferreter, Assistant District Attorney from Middlesex on behalf of the Commonwealth. As Justice Desmond, as you said in the Medeiros case, a condition must be read reasonably and with due regard to the circumstances in which it was imposed. The circumstances in which the condition was imposed in this case was the defendant was in a fight, he could have walked away from, came back and used a knife to stab a person twice, causing his death. And in this case, the New Hampshire case was similar in the fact the defendant, again, carrying a knife, kicked open a door and threatened two women with that knife. And then in the Billerica case, you can watch the video, he punches the other inmate about 5 or 6 times while he's standing. The other inmate goes to the ground. He continues to punch him another 5 or 6 times in the face, busting his lip, leaving a pool of blood on the floor.
Right,
I would
but you're
agree
but
with-
you're here. You have a defendant who has, a history at this point of making some very bad choices.
Correct. Sorry.
And sorry, I'm stuck on elementary school language, but that's how you talk to people. Sometimes it helps them hear it. And so here, she's right. We don't have, for the New Hampshire, we don't have a battery, right? We have an assault and we have a dangerous weapon, but we don't have a battery. So he's making better or less bad choices. And then in the Billerica, we have a battery, but we don't have a dangerous weapon. So, and they could have said, don't commit a crime.
Correct.
They could have said, don't commit an assault, or they could have said, don't commit a battery. They didn't say any of those things. So where's the fair, what should he have known not to do?
Violently assault people, I think is what, given the context of the plea and the facts were read, and given the circumstances of the case, I think it's a case that's similar. I think Kendrick provides guidance in this case. In Kendrick, there was a no contact with children order. The defendant went to a car show, displayed his antique car with a dog. There's no evidence that he actually talked to any children or engaged with any children, but given the facts in that, underlying facts in that case, that he had used the car and the dog to lure children, that defendant should know going around children with his antique car and his dog would violate that condition. Here we have a defendant who used a knife to stab people. I think this condition should, even though the language was not particularly clear, given the facts of the underlying case, the defendant should understand a similar offense meant, in the New Hampshire case, again, threatening people with a knife, or in the Billerica case, violently attacking someone. I would say, I know there was no serious bodily injury in the Billerica case, but I would say it wasn't for lack of effort by the defendant.
Wasn't a very good job of coming up with an explanation of what the condition was it? Similar to?
No, I think my sister is correct that they were much more focused on resolving the top-level crime, and it seemed to be a bit of an afterthought of how to actually spell this out. So it could definitely could have been better.
In the district attorney's offices these days, there's a training module that talks about what you should do when you're trying to give these conditions and how specific they should be so that you don't run into a problem like this?
I haven't attended that training, but maybe there should be. But I think they also could have, I think maybe taking a look at Rule 28E also could have provided some guidance on exactly how to spell out the conditions, because I think there were, if all of 28E was read to the defendant, there would have been two reasons to move this case off a file, which is both the committing a new offense and the probation being vacated, the assault and battery with a dangerous weapon.
Right, but they didn't do the condition of committing a new offense.
Oh, no,
It
so we
wasn't the
conceded below
standard.
and here that that is not a reason.
It might have been negotiated, right?
Correct.
Is it correct you conceded there was no serious bodily injury with either crime?
There certainly was in New Hampshire. In Massachusetts, in the Billerica case, I don't think the split lip met the legal definition of serious bodily injury. There was certainly an injury. You can see the pictures in the record appendix, and you can see on the video all the blood that was left behind. And I think the defendant tried to commit serious bodily injury, that just didn't result in happening. But given the context in which this condition was made, I think a person of reasonable, this provided reasonable guidance to a person of common intelligence. And I'd also point out that reasonable guidance does not have to describe every possible permutation or spell out every last self-evident detail. And I think a person of common intelligence would know in the circumstances of this case that continuing to use a knife, the same exact weapon that was used in the underlying crime, to threaten people or to violently, and you can see the video, it sounds like you've all watched it already, to violently attack someone would certainly be a similar offense to what he had already pled guilty to.
Is there a case that says that when you're removing from a file under Rule 28, that the standards applied with respect to how evidence is taken and the quality of the evidence are the same as for probation revocation? I didn't see such a case. I'm just wondering if there's one that exists.
I mean, because placing a case on file is a precursor to probation and they've been kind of equated so much, I think it would be the same, but I would say that the defendant below never contested any of the facts from New Hampshire and certainly not from Billerica, or never asked for an evidentiary hearing. It seemed like they all agreed to the underlying facts. But I think it would probably be the same. But he was given notice in the sense that the motion was filed beforehand and there was a hearing, and he never moved to contest any of the facts. If there are no further questions, I'll rest on my brief.
I guess, I mean, the two of us were not trial court judges, and, I had just a short time at the district attorney's office as a specially assigned ADA. When we see a case that involves a charge brought off of file, something has always gone wrong, every single time.
Correct.
Does it ever go right? I mean, I know we have a sample bias, but does it ever go right when something went on file?
I would say more frequently cases, I would say it's very rare.
It just doesn't come up, that nothing, it's just that we just have a sample bias. That
No, I don't think it comes up a lot because I don't think cases are removed from file actually all that frequently.
Okay.
So the answer is I think yes, most of the time it does go right. I think.
It's just we have a sample bias because it only gets here if it went wrong.
And what do you think our standard of review is?
So in terms of whether the violation was committed, it's abuse of discretion, or whether, but in interpreting a condition of probation is essentially a question of law, and that's from Medeiros at page 135.
Okay, that makes, did you cite a case just now to me when I was interrupting you? I'm sorry.
Sorry, it's Justice Desmond's case, Medeiros. Interpreting a condition of probation is essentially a question of law.
Okay.
That's Medeiros at 135.
I think Kendrick was my case too.
Was.
I think Kendrick was an SJC case.
Antique car.
Yeah, I think that
I
was.
believe that was an SJC case. But yes. Oh, did you try that? I'm sorry. It's quoted a lot in Medeiros. And if there are no further questions, I'll rest my brief.
We'll take a morning recess, about 15 to 20 minutes.
All rise. Court is now open. Please be seated.
Welcome back. We're ready with our fourth case, 2024 P276, Maureen E. Green versus MARYPAULA BRESNAHAN.
May it please the Court. Good morning, Your Honors. John Zajac for the appellant Maureen Green. This case concerns a settlement agreement or lack thereof that occurred on the eve of trial on a case in the Barnstable Superior Court. Leading up to the night before the trial, the parties had exchanged drafts of a settlement agreement, and on the afternoon of December 5th, 2021, the parties had believed through their counsel that telephonically they had reached an agreement and were going to continue to revise the drafts of the agreement that they had.
Right, so
I'm sorry, this was on the eve of trial, right?
Yes, it was on a Sunday afternoon and evening.
Trial was Monday morning?
Trial was Monday morning.
Some out-of-state witnesses?
There were witnesses traveling from out of state and expert witnesses.
Was Green ready for trial?
She otherwise would have been ready for trial, yes.
You see, she otherwise would have been ready for trial. What does that mean?
If she didn't think that there was a settlement, she would have been ready for trial, but because of the
She
settle...
was ready for trial for Monday morning.
Oh, yes.
Okay.
Except that based on the anticipated settlement, she had canceled her witnesses who were no longer traveling from
What do you
out of
mean
state.
anticipated settlement? That's putting the rabbit in the hat.
So the parties had already...
You were trial counsel, right?
I was, yes.
And your opponent who's here was also trial counsel?
No.
Oh, okay. But you were trial counsel. You called the court and reported that the case was settled. Presumably you did that with the agreement of opposing counsel.
I did, although I had not seen the draft of the license agreement that triggered
But you did it because you thought that you and opposing counsel had reached an agreement with respect to settling the case
I thought that we had...
on
at the
all
time that I was
material
very certain.
terms.
That's correct. And then I received a draft of an agreement that changed those terms.
And you're talking not about the settlement agreement, because you received the settlement agreement long before 11 o'clock that night, right? Were there problems with the settlement agreement or just the license agreement?
I'm glad you asked that question. So with regard to the settlement agreement, I received it, I sent back changes, and the following morning, I got back further changes again.
But you made a phone call at 8:30 the next morning and told the court that you're all set. So are you telling us that let's leave the settlement agreement for now. Are you telling us that even though you had received something from opposing counsel on the settlement agreement the day before, that you didn't have a settlement with respect to the settlement agreement? There were significant enough problems? If so, how could you call the court at 8:30 the next morning and tell them you were settled?
The settlement agreement, we had responded to the draft with some minor changes, and the settlement agreement itself was probably resolved.
Okay, good. So let's take the settlement agreement, put it aside. We got an agreement now. Why isn't the license agreement in exactly the same boat?
Because that had not been received and reviewed.
Had by 8:30 the next morning when you called the court.
It had not.
It had been received.
It had been received but not reviewed.
Well,
specifically, if you in the record, I said I was going to be available up until 11 p.m. It was emailed at 11:05 p.m.
Before 8:30 the next morning when you called the court and told them you were settled. And also, you told the court that you had a settlement. So how significant are the differences in the license agreement? How material are they?
Very.
Really? The ones you have in your brief?
Let's go through them then.
Before we go through them?
Sure.
Sure.
So before we go through them, let me just ask this question so I have this framed properly in my mind's eye. You received the licensure agreement at 11:05, right?
Yes.
Did you
Well,
review-
it was in my inbox at 11:05, yes.
Okay. Were you aware that it was in your inbox at 8:30 when you called the court the following morning?
Probably.
I don't know what that means. Either you were or you weren't. I mean,
I had not reviewed it, but I was probably aware that it was in my inbox.
so why would you have not reviewed it when you called the court to say we're settled on it, if you knew that that licensure in that language was important?
Two reasons. First, I had not anticipated that it would have the changes to the agreement that it had. That wasn't based on our discussion.
Okay.
And secondly, I had already reported the case as settled by email to the clerk, and I was following up because I hadn't received an email back from the clerk saying, we got your email, so the case is off. And third,
Right, because you intended the case to be settled, so did your opposing counsel. That's why you picked up the phone and you advised the court that it was settled. And now you want to walk away from the settlement.
it's not that we wanted to walk away from the settlement, it's that the draft agreement that we got back did not correspond to the communications between the parties in Green's estimation on points that were very important to her.
Right. So let's look at some of the specifics. So, one question I have is, do you believe that the license agreement implicitly includes a requirement of good faith and fair dealing between the parties, which is implied in every contract in Massachusetts?
That is implied in every contract.
So why doesn't that take care of some of the, the concern that, that Bresnahan's going to record the agreement merely so she can turn around and say there's no agreement? Wouldn't that breach the duty of good faith and fair dealing?
It would, but my client would be back in court litigating that issue because the agreement also says that if it's held that a term is unenforceable, which means you'd have to go back to court to have a court hold that, then you can go back and put in more reasonable terms. Secondly, even though it was in our comments saying if either party breaches the agreement, and that might be a breach of the good faith and duty of fair dealing, we insisted in our draft that went back to them that if the non-breaching party would be entitled to their attorney's fees. And they took that out. They didn't accept that.
So you had said there needed to be a bilateral attorney's fee provision.
Yes.
And so you were surprised, and you feel like opposing counsel, who I realize is not this gentleman, which I have a concern about actually, is, basically did not play fair.
Yes, that's correct. Especially because the case had already been reported settled, and they had hours to then add this language to it.
So why weren't you the person who went to the court and said, we have an agreement, Judge, we just can't get it reduced to writing because these guys aren't being reasonable? So instead of saying, put the case back on the trial list, you go and say, I want to enforce the settlement agreement that we reached the day before trial and that I reported to the court was settled. Why weren't you doing that?
Initially, because we continued to negotiate the settlement for weeks afterwards.
And you couldn't reach agreement. You think they're being unreasonable, they think you're being unreasonable, go to the court and say, we have a settlement agreement. Judge, here's what it was. Why don't we enforce that?
In a sense, we did that, because in the record, you'll see that there was a time when we came back with an agreement and we said, this is the agreement that Maureen Green would sign, and they wouldn't accept that agreement.
Well, but you didn't go to the court, see? And, I'm looking at Basis Technology. You've read that case, right?
Yes.
I mean, it says things in it like trial counsel reporting a settlement agreement are not taking out an option to settle. Talks about how serious it is to make a phone call to the court, right? The court who was all set to go to trial with you now isn't. So what I don't understand from the briefs is how you wound up with the judge saying the 1105 agreement is it. Was that litigated? Was there an evidentiary hearing on that?
There was not an evidentiary hearing on it.
How was it litigated?
So it was a very unusual procedural track. First motion that was filed was a motion to restore the case to the trial list. That motion was denied, and without any review of the agreements, the judge who decided that wrote one line saying either party may enforce the settlement agreement, whatever that means. But the court didn't know what that meant.
Right, but that's the order that I'm asking about is the one that says the agreement is the license agreement as of 11:05 the night before, and you are ordered to sign it. How did that happen?
So the court scheduled, two things happened. First, twice the defendant, Ms. Bresnahan, filed motions to enforce the settlement agreement. We opposed them under 9A, so no court involvement at that point, and they withdrew those motions. Then, and it took about, I think, 10 months to get there, the court scheduled a hearing on the motion for reconsideration. At the motion for reconsideration of the reinstatement to the trial list, not the enforcement of the settlement agreement, the court accepted filings of the motion to enforce and the opposition to it.
So there was a motion to enforce, there was an opposition, and the court ruled on that 10 months later.
At least, yes.
And it was their motion to enforce and your opposition?
Yes, and it wasn't filed under the normal 9A procedures. It was filed in the course of the
Why
hearing.
were you opposing a motion to enforce? Why weren't you saying, yep, you should enforce, it's just a different agreement?
We actually did argue that as well. We said if there's an agreement to enforce, it's not the 11:05 p.m. agreement.
That was argued out before the judge
Yes,
on a non-evidentiary basis.
on a non-evident, just based on the record of the,
Do we have the pleadings in our record of the motion to enforce and the opposition thereto that led to the judge's decision?
yes,
And do we have the hearing transcript?
yes.
Did you, in your motion to reconsider, did you argue changed circumstances or newly discovered evidence?
Both, but yes.
Okay.
I would submit. With regard to the motion to reinstate to the trial list, we argued that the court didn't have the record as to what the negotiations had, a full record as to what the negotiations had been up to that point, and therefore, what does enforce the agreement mean when the parties don't agree on what the agreement means? Because we had a different version of what the agreement meant.
But only on, I mean, you've identified 4 issues. One is mutuality of attorney's fees, right? One is the date on which the fence has to be built.
Yes.
As to which I understand you are 30 days apart. There are 2 more, and I wrote them down.
Stuff
One is
blowing
that
against the fence.
There's a clause that says she can't in any way touch the fence, basically, and you couldn't get that one fixed. And the last one is that the way it's written, one could arguably read it so that if the other side recorded the license agreement, the license would go away.
Yes. Those were the 4 main issues with regard to licensing.
It took me less than a minute and a half to figure out how the agreement might be amended so that there would be no problem with those 4 issues.
And that's not what the trial court did.
Well, but is that because you were objecting? By the time he filed a motion, they filed a motion to enforce the agreement, you were objecting rather than saying, you know what, you should enforce the agreement, here are the 4 problems and here's how to solve them.
We actually did we submitted a different version with changes to the agreement that Ms. Green felt addressed those issues.
So, you argue the standard of review should be de novo because the motion judge only relied on documentary evidence. He's going to get up in a minute and say the judge made some credibility determinations. Who's what? How do we determine which is correct?
I think it's difficult to argue that the judge made credibility determinations when the decisions are so short. And simply that I don't think there's a dispute as to when we received the agreement, when we reported the case settled, and what transpired after that.
So, speaking to what transpired after that, it seemed you were very diligent about reporting the matter settled. How come you didn't move to vacate the dismissal nisi within 6 weeks?
Basically because the negotiations were ongoing, and I still was hopeful that we were going to reach the...
At some point, you knew you weren't. At some point, you knew that you had a deadline, and you didn't act. But we know you can be very diligent, because you were in reporting the case settled. So what was the problem there? Why did you let that deadline go by and then move to restore it, rather than act within the 6-week window?
The honest answer is that I had been in contact with the Superior Court and was following their instructions. I know that's not in the record, but I was doing what I was told by the clerk's office.
Which was to let that date pass?
And file a motion to reinstate it to the trial list.
Can you address the argument that your appeal was not timely because you didn't file a notice of appeal following the July 26th entry of judgment, and your prior notices of appeal had only been for interlocutory orders?
Yes, because there was the issue was raised differently in the trial court, there was a motion to dismiss the appeal that was filed. And on the decision on that, the judge was very clear that Ms. Green's notice of appeal is timely and defendant's motion to dismiss is denied. So the trial court found that there had been a timely appeal filed. And I didn't think it was necessary, therefore, to file a second notice of appeal when the trial court was already saying that it was timely filed and that the appellate rights had been preserved.
With respect to the notices of appeal that had already been filed, would say your opponent. Right? I mean, that's what we're fighting about. The judgment hadn't entered. Everything else was interlocutory. Once judgment entered, you should have filed another notice of appeal, because that's how we do things.
I think that contradicts the decision that the court made on that the trial court made on that motion.
Appellate rights are preserved. I'm not quite sure what that means, how your appellate rights could be preserved with respect to an order that had not yet entered. Although he did order that judgment be entered in that same opinion. Okay.
I think we understand.
Thank you.
Thank you.
Good morning, Your Honors. May it please the Court. Stephen Rosenthal, representing the appellee, MARYPAULA Bresnahan. The appellant has 3 hurdles to clear in this matter, and it's the appellee's position that she has cleared none of them. The first is procedural in nature. The second 2 have to do with the scope of review. So let's deal with the procedural problem first.
As you stand here right now, do you believe you had an agreement?
There was the agreement that the judge said was reached as of...
I'm asking you, as you stand here right now, did you believe that you had an agreement as of 11 o'clock on December 5?
Yes, Your Honor. That's what my client understood, and that's what trial counsel understood.
With the unilateral attorney fee provision?
Well, Your Honor, if I can quote from a case that I think is relevant here, it's not required that all terms of the agreement be precisely specified, and the presence of undefined or unspecified terms will not necessarily preclude the termination of a binding agreement. That's the situation
then why
management case.
Yeah, but attorney's fees are the killer, right? It's a club, I mean, a giant club. So why shouldn't the trial court here have said, no, nobody's getting fees or you're both getting fees? Why shouldn't they have asked the question and made your predecessor say he's not telling the truth?
Your Honor, the problem here is that appellant notified the court not once but twice that the case was settled.
Yeah, but we really like some justice and fairness and candor to the tribunal. And you don't slip terms in. I mean, anyone who reports a case settled without having a signed agreement is doing so at their peril. But we also don't let people slip in terms that weren't agreed to. And so it was a simple matter to say, was there a bilateral attorney fee provision, a unilateral or no attorney fee provision, and get counsel to report?
I don't think that means that the term awarding attorney's fees was slipped in at the last minute.
Well,
Apparently-
we've got a person who seems very credible, at least to me, saying we did not agree to a unilateral attorney fee provision, right?
The issues that came up that, that trial counsel for the appellant was complaining about was not necessarily the attorney's fees part of it, although that's something that could have been resolved if he had brought it up within the 6 weeks or so that
You're
he
saying
had.
he didn't bring up these issues within the 6 weeks?
No, he did
You
not.
guys were negotiating for 6 weeks. What issues were they bringing up?
Primarily, the issue regarding anything touching the fence.
Well, okay, which was that a new add to the license agreement?
No, it wasn't, well, it was added that there should not be items that would be
Or
up
any
against
other
the fence.
object, or any other
objects. Yes.
That was added at 11 o'clock at night. He says, that's no good because, I don't know, the neighbor's dog might run over and hit the fence, and now you guys are going to say there's no agreement anymore. Come on.
Your Honor, you referred to the covenant of good faith and fair dealing.
Right, but why
And-
doesn't the covenant of good faith and fair dealing say, let's have a reasonable negotiation now and get that language out? Because that language doesn't make any sense. It's too broad. And there's, all you got to do is add a couple reasonablenesses to it, and we're fine.
Your Honor,
So why didn't that happen, counsel? Why didn't that happen?
Your Honor, the appellant wouldn't take yes for an answer. There were further negotiations. There were things that my client agreed to, in addition to what had been in the settlement agreement that was reached as of 11:05 the night before trial.
But counsel, it's a cute answer to say they wouldn't take yes for an answer, but the provisions that he's raised before us are quite reasonable. And to say it's very one-sided, and I would say it would be a violation of the implied covenant of good faith and fair dealing to run in and record the contract so that it could be voided. I don't think your client could get away with that, so why wouldn't your client fix that?
Well, Your Honor, it would make no sense for my client to
Oh, no,
to
these two are
record-
behaving like people in the backseat of the car that somebody's over the line. This is, he touched me, he's on my side of the car. Like, this is really, to be honest, ridiculous that your clients have not resolved this. They should be embarrassed that they have not resolved this.
Well, apparently what the
And I don't know why, I don't know whether she's paying him. She could have the fence and then build another fence 8 inches away so that she didn't ever have to worry about anything touching the other lady's fence. But, I mean, these are grown people that are acting this way. It's...
But it's not an answer to the question. When you say, I lost my thread, I apologize. But, there was a question asked, and the trouble I have is if these were the issues that were raised, or some of them, okay, both parties should have been going into the court and saying, we have an agreement, Judge, why don't you solve these 3 or 4 issues? They're not material.
My brother was the one who was unhappy with the agreement in the form that existed when the judge approved it.
So you took the position, but you took the position it should be the 1105. Your predecessor took the position it should.
That's what the trial judge said.
Well, he said it, but you took the position it should be, and presumably the arguments that we're now hearing were made before you said it should be the 1105. In other words, you folks also didn't say, you know what, we can make a few adjustments to these 4 issues before we ask the judge to enforce the agreement. That didn't happen, did it?
No, it did not.
Okay. And all right.
But I have to,
So-
I have to
And
come
the
back and
lawyers
say,
acting like the clients in this case?
I'm sorry, Your Honor?
Are the lawyers acting like the clients in this case? Is that what happened? Everybody just dug in?
well, I wasn't the lawyer below, so I can't say.
And he says, send me the agreement by 11 o'clock, and you send it 11:05.
I don't think that was for a devious purpose. And in any event, as was pointed out, the agreement was received at 11:05, and the
With a
plaintiff-
bunch
the
of
plaintiff-
changes to it, some of which look like, geez, how could you possibly think that was going to be acceptable under circumstances where it's already been reported? And when you say, he called the court, I hate that. You both called the court. You agreed, both of you, that the case was settled. That was the intent. So
Yes.
it's not his fault that he called the court. You both called the court. You both reported it settled. And then at 11:05, you send him something that has a bunch of changes to it. And I say you because obviously the person who did it is not sitting in that chair. You call the court, you send something at 11:05, and you know he can't agree to it. So and then, okay, he makes a mistake, right? He doesn't read it carefully before, worried that the court might not have got his notice at 6:30 the night before. He reasonably calls the court to make sure the court had the message from the night before. That's a mistake on his part, but boy, why are you sending him stuff at 11:05 that's new?
It wasn't done because, oh, we wanted to slip this in. It was done because it took time to get the agreements in the proper form. And I would point out that on December 6th, on the day of trial, the judge entered a dismissal nisi order. And it said you have until January 14 to resolve whatever problems there are. Come in if you're saying that the case hasn't been settled, and if not, the case will be dismissed.
If there were,
And neither side went in, right?
I'm sorry?
Neither side went in.
It did enter, that's correct. And then my brother filed the motion to restore the case to the trial list. And then we get into...
That was another 2 months later, though, right? That January 6th was the dismissal nisi.
Yep.
He doesn't file a motion until March 25th to restore it to the trial track.
That's correct, Your Honor. And then when that motion was denied, he filed a motion to reconsider.
Do you think it would violate the covenant of good faith and fair dealing for your client, as soon as this is signed, to run in and record it so that it would be void?
It makes no sense for my client to
No, I
run
want to
in
know
every...
if it would violate the covenant of good faith and fair dealing, because it is possible that y'all could resolve this case before we write a decision. And if this is not an issue, because you both agree it would violate the covenant of good faith and fair dealing, then you have fewer issues to resolve. So would it violate the covenant?
It would violate the covenant, but there's no reason for my client to do that.
Okay, and what about if, somebody's leaves blew up against the fence, or somebody's beach ball blew up against the fence, but it wasn't Green's beach ball? Would that violate the covenant of good faith and fair dealing if she did not somehow magically prevent anything from blowing up against the fence?
I don't believe that would be a violation of the covenant of good faith and fair dealing, because the parties are supposed to act in a reasonable manner. Is it reasonable that somebody else's beach ball blew up against the fence and to be upset about that? I don't think so.
Have they acted reasonably so far?
I'm sorry?
Have they acted reasonably so far? What is going to make me think that after all of this litigation, where it seems like no side's acting reasonably, that all of a sudden, with the signing of a piece of paper, they're going to act reasonably for one another? I mean, is that even realistic, given the facts of this case?
how hard is it going to be to add the language about reasonableness so that both parties can agree?
That's something that we can discuss.
How hard is it going to be to say, because really, as you say, my client has no incentive to record the license, and frankly, if your client did, I don't think that Green would care. How hard is it to say that, something like, neither party shall do this, but, the opposing party may at their option, if a party does, the opposing party may at their option declare it void? How hard would it have been to put in a clause like that? I mean, these things are so easily soluble if this is what we're really talking about.
So is it your representation of the court that Green's attorney agreed to a unilateral provision for the award of attorney's fees?
He did not object to it in a timely manner.
Did he agree to it at the time that the case was reported settled?
He agreed to whatever was in the agreement, which included that provision. I don't know how else to answer you.
Why shouldn't we send it back and tell the judge to make a factual finding about whether or not he agreed to a unilateral fee position?
the problem, which I've never had a chance to get to in my time here so far, is that the appeal is procedurally defective because there was a final judgment.
The SJC has really knocked that out of the park with Rock versus Malika, where they dropped a little footnote saying, yeah, this wasn't perfect, but we're letting it go because we don't do gotcha anymore with notices of appeal. And we've followed suit in a published decision called Tachi Building Corporation, and then we've followed suit in unpublished decisions.
Well, the way I read it, it's like something that they can overlook if the other side isn't going to be prejudiced. And in this case, my client would be prejudiced if that procedural defect was ignored.
I think if we're going to criticize him, he's being too nice a guy and too like, this is going to work out because I'm following what the clerk said, and he needs to, I don't want to turn him into the pit bull that lawyers are reported to be, but his life will be not here as often if he becomes that pit bull. But the flip side is that if you know that at 11:05 that you had not discussed a bilateral attorney's fee provision, that then you admit that and you go forward on that basis. I'm not hearing you say that at 11:05 the parties had expressly discussed a unilateral fee provision.
It's my understanding that this unilateral provision was not added at the literally the 11th hour. It had been discussed before that. And it was not something, and, you know, the attorney for the plaintiff in that case had numerous opportunities to go through the agreement, and there were red-line versions that went back and forth.
But you both reported it settled, so whatever was left, nobody thought was material. You thought you were going to reach agreement on this stuff, right?
That's true.
You really thought you were going to reach agreement on only your client gets fees if there's a breach, but his client doesn't, if your client breaches? That's a tough one. It's also any object hitting the fence. That's a tough one. And that was added, you said, I think, at 11:05 that night. You say you were prejudiced by them filing the notice of appeal, or by them claiming that this appeal is timely? I don't understand that, where you have a judge's order that says that it denies a request previously that the appeal's untimely and should be dismissed, right? So how did you develop prejudice when you had an order from the trial court that already had rejected the argument that the appeal was timely or untimely?
The court rejected the untimeliness of the appeal of the various interlocutory orders, but there had been no final judgment yet. It's like
I understand that.
Well,
you understand my question. How did you develop prejudice in light of the fact that you had that order sitting there? How did your client develop prejudice?
the longer this matter has gone on, the more my client has had a cloud on the title to her property. There's a claim for adverse possession against her. She can't sell the property without anybody doing due diligence finding that out.
Settlement will remove the cloud.
The other thing is that she was going to pay to move the fence. And the price, we can imagine, has gone up considerably in the past 3 years.
Right, but the prejudice would be from knowing the judge has said his appellate rights are preserved and not knowing that. I don't see how that affects what you just said falls into that issue. She knew they were trying to appeal.
She was trying to appeal, but she was appealing the motion to enforce the agreement and the various motions for reconsideration.
I think what you're hearing is your client is winning some debaters' points, but that's not necessarily going to result in success or save her money.
Well, Your Honor, I see my time has expired. If there,
I have a question.
yes,
Was she looking to sell the house?
I'm sorry?
Was she looking to sell the house? You said there's a cloud on the property. Was she looking to sell?
No, not at this time, but it's something that could happen in the future.
Hypothetical, whatever. And my second question is, were you guys just sending drafts back and forth, or were you actually on the phone talking to each other?
My understanding is that there were drafts going back and forth electronically.
My understanding, too.
If there are no further questions, I will rest on my brief. One last point. I did not receive a reply brief from the appellant in this case, and it would have been helpful to be able to respond to whatever response he had to my arguments. So, thank you, Your Honor.
All right, well, I think we do occasionally, after argument, encourage parties to reconsider whether they could resolve a case, and I would encourage your clients to reconsider whether they can resolve the case. If you leave it with us, there's no guarantee either one of you will be happy, but you are grown adults who are acting like people in the backseat of a car, arguing over the invisible line between them, so you do what you deem fit.
Thank you.
With that, I will call case 2024-P17, Kevin Concannon versus Edward Smith. Yes. And I'm sure, Attorney Curran, you're the consummate professional that you understand that you can only argue for your client, you cannot argue for the mother.
Yes, I've made that point to my client many times. I am not intending to argue for the mother. I probably will end up throwing her under the bus a few times.
Okay, and just so the record is clear, she has chosen, this is not for you to make a representation, but she has chosen not to appear today.
Yes.
Okay.
May it please the court, Dana Curhan for Robert Mashinsky. In this case, the trial court imposed a constructive trust on the property, ordering that Mashinsky convey the house lot to Dorothy, who could then convey it to the plaintiffs. The trial court concluded, notwithstanding that the documents on their face leave the property to Mr. Mashinsky, that he was actually a straw holding it for his...
Well, they didn't say straw, did they? The judge didn't say straw. He said there was an agency relationship.
Yes. I mean, it's really the same thing. He's holding it for their benefit. And
why?
So notwithstanding what you say is apparent on the papers, was the judge prohibited from looking to the conduct, which he thought was very telling?
No, he's not. But you know, this is kind of an unusual case. When you have a constructive trust case, most of the time you have some kind of fraud or unfair dealing or whatever. The judge in this case, the judge who was the trial judge, actually granted the defendant's motion for summary judgment on fraud, intentional misrepresentation, and negligent misrepresentation.
Not on something called constructive trust. And you say in your brief that constructive trust is a remedy, not a cause of action. You have a case for that?
Off the top of my head, no. I mean, I think there are. I'm not thinking of anything, but I believe that is the case law that I cited in the brief. I think indicates that it is a remedy.
So, why is this not a credibility situation where your client testified, I inherited this property, it was not as an agent, and the judge did not credit that testimony, which, as you know, we can't do anything about that. Why is that not this situation?
Well, I think to back up, the plaintiffs had the burden in their case in chief. They established that title was in the name of Mr. Mashinsky, that the mother believed that she owned the property. But that's really it.
No, I thought they also established that by putting it in the name of the son, they avoided losing the whole thing in bankruptcy.
Well, I mean, that was also indicated. I don't think there's any real details about the bankruptcy, except for the fact that it existed. The problem is, I think there was some discussion at the close of the plaintiff's case that there's a lawyer in Quincy who drafted this document, and he was never called.
Right, but
Attorney
those-
Mullen, right? Go ahead. Mullen.
I'm sorry?
That's Attorney Mullen?
Attorney Mullen.
But their response to that is that he would just invoke privilege. Why is that wrong?
I don't think he could, I'm not sure if he could invoke privilege. If he's working for Mr. Allen and he was actually paid by the stepfather, Mr. Smith, I think the privilege could be waived. But, I mean, he could indicate whether there, what the intention was and whether there's a side agreement, some kind of oral agreement or some kind of written agreement.
But just kind of looking at things, from a broader perspective, it appears, and if there's some dispute factually, stop me. It appears that the parents and the son had engaged in similar type of activity before when the parents were going through various bankruptcies. That is, giving properties to the son, taking them out of the parent's name, waiting for the bankruptcy matters to be resolved, and then have phenomenal consideration, having the properties back into the parent's name. Do you agree with that?
No, I think the testimony was that there was one property that they put it into his name and took it out, but he didn't know about it. The other properties, they put it into trust that they had and then transferred it back.
And was he a trustee?
I don't believe so, no. So, there was testimony from the real estate broker that she had a conversation with the stepfather who said, I was advised to put it in his name for tax purposes, but nobody ever talked about what the tax benefits might be.
And Mr. Machinsky's position is, I was friendly with this 92-year-old gentleman, and so he gave me all the property.
Yes, and the attorney, I think Attorney Cerrone, called him up and said, hey, this is in your name, but you need to transfer it to your parents. And he said, well, he seemed very surprised and said, it's my property.
And let me ask another question. One of the lots seems to be a small piece that falls down into the ocean. Is that buildable?
There was testimony, I believe the mother was, Dorothy, said she didn't know. Now, that's on the exhibits volume, page 87, it actually shows them.
Doesn't Machinsky say the reason that I gave them that property was because I was concerned that somebody would try to build on it and obstruct their ocean view?
Yes, he did.
Okay, and wasn't the judge free to reject that?
I think he did, but I don't think he made any findings. The thing is, the findings were kind of a checklist.
Agreement, right?
By agreement, and I don't dispute.
About that now.
I'm not complaining about it, but there's no specific finding. The findings are sparse, let me put it that way. So,
as you anticipated, that's why you
right.
agreed to it.
So, but there's no specific finding that, I don't believe Machinsky when he says that this was not a buildable lot. So, we're left with a record that is very sparse, and especially in the plaintiff's case in chief, where, so everybody, I suppose either side could have.
Mr. Carhan, can I
Yes.
just interrupt for a second? Are you making only a factual argument, or are you also making a legal argument?
I think I'm making a legal argument that
About the scope of constructive trust and when that's available?
I think I am, but also, factually, the plaintiffs had the burden of showing that there was something that was unfair that warranted the imposition of a constructive trust. And I think I suggest that on the plaintiff's case, that just didn't happen. I mean, I think there may have been a mutual mistake. The Mashinsky and his
You mean
parents-
as between the parent and the child?
Yes. So, you know, there was a misunderstanding of what was conveyed. I mean, everybody thought, the parents both thought that when Mashinsky deeded the two lots, and one of them being the rocky part and the other being a little sliver in the front of his property, that they had conveyed the whole thing, and they believed that they therefore owned everything.
Wasn't there testimony that when the neighbor, whose name escapes me right now, 92-year-old gentleman, Crane, what's his name?
Mr. Allen,
When he was going to give the properties to the parents, they both believed that they were inheriting these properties and that they had spoken to counsel, and counsel had advised them to put the properties into their son's name because of some litigation that they were going through. And they instructed Mr. Allen to do just that.
there was testimony that the broker said, that the stepfather said that they were advised to put it in Mashinsky's name for tax purposes, without any discussion about what the tax purposes might have been.
Right. And then acting on that, he told Mr. Allen, put it in my son's name. Is there any evidence that Allen ever told Mashinsky, hey, I'm going to put this property in your name?
Well, Mashinsky said that.
Did Mashinsky ever pay any taxes on the property?
No, what he testified to was that he told his mother and stepfather, look, go and you can rent it out, keep the money, just pay the taxes and the expenses. And then later on, when this whole dispute started, Mashinsky came in and put a couple of $100,000 worth of renovations into the property. Probably shouldn't have done that.
Builder's permit.
I think he did have it. He had
At his
engineering.
own risk, right?
I'm sorry?
He knew that there was a lis pendens on the property. That was at his own risk. Whatever
Yeah.
he spent, that's not our
Yep.
concern, right?
I don't dispute that.
What I'm troubled by is the form of action. That's what I'm troubled by. They were covered under a theory of breach of contract and breach of implied covenant, good faith, and fair dealing. Am I right?
That's right.
Anything else?
I
There's a reference in finding 5 to constructive trust. You say that's not even a cause of action. I have to tell you instinctively to me, it's not a cause of action, but the case you cite for that proposition does not say it. So I'm sort of stuck here with what is the form of action, because the contract was not with your client.
The contract actually says that the remedy for a breach or for an inability to perform, let me put it that way, is the parties walk away. And that is what I contend is should have been their remedy. The remedy is not to go and say to Mashinsky, you got to give the property over
You
to...
don't have a contract with Mashinsky.
Right.
Mashinsky is a stranger to the entire matter. They have no claim against Mashinsky because they have no relationship with Mashinsky. The only way they can get to that property is through a theory of constructive trust.
Well,
right?
I think if there were, for example, there was a count for fraud. If there had been a fraud and that had proceeded, then certainly they could have imposed a constructive trust.
Like the case where after the deal is done, they transfer the property out to somebody else, and the court says, no, you can't do that. We're going to bring it back.
Right.
Right?
Right.
Fraudulent transfer or some theory like that.
Right, exactly.
But isn't there a mistake or some other circumstance language as well?
Well, I think there's mistake language, or there's something, if you're unable to perform, which would apply to a mistake, then the remedy is the contract is canceled, the contract is rescinded, and that's what the broker actually said. Can we have everybody sign mutual releases? And they said no. So I think because there was a directed verdict on all of the things that would normally trigger a constructive trust, all you have is the breach of contract and maybe a breach of the covenant of good faith and fair dealing, but I don't think there's anything there that allows them to get Mashinsky to order him to hand over the property. That's really the problem. And I think at the close of the plaintiff's evidence, disregarding anything Mashinsky said, but at the close of the evidence, I think the judge should have directed a verdict. There was argument after the close. Nobody used the words directed verdict, but I think that's what they were, in a jury waive trial, that's what they were arguing about.
If Mashinsky is an agent, can he be ordered to turn over the property?
If he's an agent,
Can he be ordered to turn over?
well, I mean, if he's strictly an agent, if there's something establishing that relationship.
I'm just asking, if he's an agent, can he be ordered to turn the property over to his parents or his mom?
Maybe. I'm not sure the theory. I'm not sure.
If the parents had sued him, he could have been ordered to turn over the property to his parents.
I'm sorry, if the parents.
If the parents had sued him, he could have been ordered to turn over the property to his parents because the judge found that there was an agency contract between him and his parents. But his parents did not sue him, right?
Yes.
So then we have the next issue, which is on a suit by these plaintiffs, what can the parents, who are the only contracting parties, be ordered to do?
I'm not sure if they can be ordered to do anything.
They can be specific performances. I mean, they certainly can be ordered to turn over the properties that they held title to.
Right. That's right. They didn't hold title to this, and I think the judge found that. Unless there are any further questions, I will rest on my brief.
Thank you very much. I think we understand your position, and now we'll hear from your colleague.
Good morning, Your Honors. I'm Joseph Brodigan, Sr. This is Joseph Brodigan, Jr. with me. I represent the plaintiffs in this case, Mr. Concannon and his wife, Ms. Sorgi. Your Honor, this is indeed an action for specific performance, for breach of a covenant of good faith and fair dealing, for breach of contract, and a request for the establishment of a constructive trust. And the count that requests that remedy specifically states that it is being requested to prevent an unjust enrichment.
So is it a separate cause of action under our law, constructive trust, or is it a remedy for the other causes of action that you've just identified?
It probably is not a separate cause of action, but it is a remedy which is available in the face of unjust enrichment, Your Honor, and all...
Unjust enrichment would be at your client's expense, and there was no unjust enrichment of Mashinsky at your client's expense.
There was an unjust enrichment of Mashinsky.
But your clients had no relationship with him.
But, but, Your Honor, Mashinsky was the person who would end up with the property that his parents were supposed to order him.
You're saying this is unfair because the parents are leaving the property with their son. Is that the argument?
Yes, it is the argument, Your Honor.
Why do they have any? Why do they? So, this is the way I'm analyzing it. So, you have free opportunity to argue me off of it. You're arguing we are a third-party beneficiary to the agency relationship. Let me finish.
I'm sorry, Your Honor.
You're arguing, this is the way I see it, so you have to explain to me why I'm wrong. We, my clients, are a third-party beneficiary to an agency relationship between the Smiths and their son, and therefore we are entitled to enforce their agency contract and require the property that he should have to give to his parents to be given to us.
And that last piece, Your Honor, the requirement that Mashinsky transfer the property to the parents so the parents can transfer it to my clients in consideration of the purchase price is exactly why I need the constructive trust.
Stop. Because the third-party beneficiary law, if we're going to follow that, says you're not entitled to anything because the contract of agency that you're claiming existed and that the judge found is not for the benefit of your client. It's only for the benefit of the Smiths.
But the
And it has
agent,
to be for the benefit of your client in order for your client to be a third-party beneficiary, as I understand the law.
but Your Honor, it is ultimately for the benefit of my client. And the benefit to my client is the fulfillment of his contractual obligation to obtain
The contract itself, this agency contract that the judge finds in Clause 1 of his findings, if it's a third-party beneficiary theory, that contract had to be made for the benefit of your client. That would be the only way that your client would have a right as a third-party beneficiary. Now, maybe there's some other way to get there.
Well, I think the way to get there, Your Honor, is precisely what the judge did. I don't have to go through the third-party beneficiary client because a constructive trust is such a flexible tool of equity that what it does is just look at any situation of any nature, and if there's been a breach of a fiduciary duty, here the breach is the fiduciary duty owed by Machinsky to his parents.
The judge did not find a breach of fiduciary duty. He found a breach of an agency agreement. That's the only thing you have a finding of, that and a separate breach of the covenant of faith and fair dealing. The fiduciary duty is not mentioned, so I don't think we should talk about it, should we?
What is not mentioned?
It's not mentioned in the judge's findings. Was not asked for, it's not found, and therefore I don't think we should be talking about that. Am I wrong?
No, what was asked for, Your Honor, was the imposition of the constructive trust. Because of the breach of the agency agreement, Your Honor, let's go the way that you just indicated. Because of that breach of that agency agreement, my people are hurt. They are deprived of their contract right. And as you pointed out a few moments ago, the breach of that agency agreement is between a parent, the parents, step-parent, and a child, Your Honor. Very, very close relationship here. But he was their agent.
The parents never sued the child.
The judge found that he was their agent, Your Honor. And the judge ordered that the agent convey to the parents so the parents can fulfill their contractual obligation.
Parents never, so there's a contract which you sued on as to which Mashinsky's he's not a party. He's a stranger to it, just with the Smiths. And then there's an agency contract, and that agency contract is between the Smiths and their son. Parents never sued on that contract. Parents never said, hey, give us the property that you were supposed to give us years ago. They never did that.
Expand that, Your Honor, a little bit, because the purchase and sale agreement says that the sellers must use reasonable efforts to convey the property. They must use reasonable efforts. In the stepfather's deposition.
So let me make sure I understand. So that theory is that the judge has the power in equity to order the parents to bring the lawsuit that they never brought.
I think what the judge has the power to do on all of these facts, and what he in fact did do, was said, agent, transfer to your principal. Principal, obey your obligation under the purchase and sale agreement. And he did that, Your Honor, within the context of...
Why do your clients have the ability to get a judge to order the compliance with the contract as to which they are strangers, the one between the Smiths and their son? Why do your clients have through their suit, have the ability, what's the claim that gives them the ability to get the judge to order that?
Because, Your Honor, this whole thing is based on testimony that almost reaches the nonsensical, because, Your Honor, that the Smiths themselves admitted, at least Ed Smith admitted, Your Honor, that the property was to go into his name, into Machinsky's name for tax purposes, and then what wasn't discussed earlier, The rest of that conversation was, and then it was to be conveyed by Muczynski back to the Smiths. Back to the Smiths.
I understand the factual basis.
Let me state.
I'm not really arguing with the factual bases that you.
Let me state, Your Honor, let me state it this way, if I may. What the parties testified to is that the real owners of the property were the Smiths. They owned it. They stuck it in their son's name because they had an open bankruptcy case pending, Judge.
He's holding it as a nominee.
He's holding it as their agent, Your Honor. He's holding it as their agent, not just a nominee. A nominee.
If it's an agency agreement, can't they then just decide, you know what, we've changed. We don't want our son to have to give it to us anymore. In fact, now we're 20 years older, he can keep it.
You can't change it after the fact, Judge. If they want it.
Well, of course, the Smiths and their son, who have a contract, can decide whether or not they're going to enforce that.
Not to the detriment of my clients. Not to the detriment of my clients.
I was totally unaware of it.
If they did that. Sorry, Judge.
There's no fact that suggests that your client had any knowledge going in about the fact that Muczynski even owned it, let alone that there was some sort of agency relationship associated
Well, that's what they say. That's what they say. I mean, the judge didn't find one fact in favor of the defendants in this case, Your Honor. Not one. He didn't believe them. He didn't believe, as Judge Henry said, this is strictly a matter of credibility.
The Smiths? He didn't believe who? The Smiths? The judge didn't believe the Smiths? Is that what you're saying?
I'm sorry, Judge, I can't hear you.
When you say the judge didn't believe them, didn't believe who?
Didn't believe the Smiths, didn't believe Muczynski. Didn't believe any of them.
Don't the Smiths say that my son is now not willing to sell us the property?
That's what they said. The judge didn't believe that. That's what they said. He didn't believe almost anything that they said, Your Honor, with excellent cause.
He believed that they said, hey, we inherited the property, it's our property. He believed that, right?
Well, the Smiths said that.
Yeah.
Which indicates that they're the true owners of the property.
So the judge believed that?
The judge did believe that. Yes, he did believe that.
Could the judge, I mean, so at some point, Muczynski says, well, I want $1.1 million for the property, and your clients understandably said no. Could the judge have ordered the Smiths to pay him the $1.1 million?
No. No, the judge had no right to do that. He can't raise the price above and beyond the purchase price, Your Honor. And, Your Honor, that point goes right to the heart of the case. Right during all of this, Your Honor, when Muczynski refused to convey the property, he increases the purchase price for all three parcels, for the whole thing, doubles it. That indicates what his intent is here. That indicates what's really going on in this case. And, Judge, by increasing the entire purchase price, increasing the purchase price for all the parcels, even then, when the fat is going into the fire, when it's getting hot, Judge, he's still acting as his parents' agents. He's speaking for them. He's saying, don't increase the purchase price for just James parcel with the house on it. The whole thing, increase it for the whole thing. He is still acting for them at this point. Judge, the facts here, I suggest, clearly indicate that the Smiths were the true owners of the property for 20 years. For 20 years, they paid the taxes, paid all the expenses. They mortgaged it in 2012.
That is pretty.
They mortgaged it, Your Honor, and put the mortgage money in their own pocket.
Claim they were the owners, right?
Pardon me?
In those mortgage papers, they said that they were the owners of the property.
They said that they were the owners.
Hell of a title search done by Santander. Must have been superb. Look, here's the problem, and I started to say it earlier, and from my perspective, and I'm not speaking for anyone else on this panel, I can agree with every fact that's found, every fact that you've stated, that the judge didn't believe Muczynski, okay, that the parents thought that the property was in their name, that they even thought that Muczynski had transferred the property to them in 2003. My difficulty is with the legal theory. It's with the legal theory, and I think you're reduced to what you said earlier, which is that the judge has the power, sitting in equity, to impose a constructive trust on the property here, despite the fact that your clients are strangers to the relationship between Mashinsky and the Smiths.
I would suggest, yes, I am saying that. And I would also just point out, Your Honor, they are not really strangers to all of this, because they have a written contract to buy it.
No, the written contract is not with Mashinsky. The very first few lines, they say who the contract's between. It's between your clients and the Smiths, not with Mashinsky. He's a stranger to the contract.
He's a stranger to the contract, Your Honor, before it was discovered that he was the agent of the parent. So if he's the agent of the parent, if he's under their control by the agency agreement, if he owes them by law the duty of utmost good faith and obedience, then he's not a stranger to the contract at that point in time.
I have difficulty with that. Usually I figure out who's on the contract by looking at the names, and then I ask the question, are there any third parties who are intended to be benefited by this? That's third-party beneficiary law. And that's why I went where I did earlier.
But my clients...
What's wrong? What am I wrong?
Sorry.
Am I wrong about my understanding of the contract law?
I think you are, Your Honor. I think you are looking at it wrong, because my clients aren't third-party beneficiaries of this contract. They're contracting parties. They're part of the contract. They're part of it. They're entitled to the fruits of their contract, Your Honor, in a situation where you have a family-related defendants who are cooking up a story, Your Honor, and hiding behind that story. And in Ed Smith's deposition, he testified that he never took any step whatsoever to require his stepson Muchinsky to comply with the contract and sell it. That was his testimony.
So that would be, in your view, a breach of the contractual clause that says he has to make reasonable efforts to solve any title problems.
Yeah, Your Honor, that's so.
Okay.
That's so, but the remedy here is equitable. I'm looking for real estate. I'm looking for something unique. How do I get that real estate out of Muchinsky's name into my client's name? And the judge even references Rule 7, Civil Rule of Procedure 70, Your Honor, where the judge can appoint a special master in the case to effectuate that conveyance, to execute a deed to my people. So he's trying to do that. He's trying to get that special property, not money, over into my client's name. Your Honor, I suggest that this case is really tailor-made for a constructive trust.
Do you have, last question.
No, go ahead.
Do you have, what would be the best one or two constructive trust cases that
Sorry, Judge.
Sorry. What would be the best one or two constructive trust cases that you would send me to so that I would understand that the judge has the power to do what he did here?
The broad power of constructive trust, I think, is best explained in the Maffey case.
Maffey.
And right behind it, the Fortin case. And behind that,
Sorry,
Tucker v.
Maffey, and what was the second one?
The second one is Fortin.
Fortin.
Fortin versus the Archbishop of Worcester. And then Tucker versus Connors, judge right there. Those 3 or 4 cases, and Kahn versus Barry that the judge cites in his thing. It's just such a flexible remedy, Judge, that it's applicable where you have a breach of fiduciary duty, which you do, and where you have a party being detrimentally affected, which you do with my clients, and where somebody is unjustly enriched. If there's no remedy here, Judge, if there's no action here, in favor of the plaintiffs, what happens is Muchinsky ends up with a property.
Because his parents decided not to take it back.
Parents decided not to take it back. After, Judge, it's discovered that he was the agent. The only thing the parents did is they said, we're not going to cause Muchinsky to do anything. They didn't take it back. There's no evidence at all that they took it back.
Very well argued. I think we understand
Thank you very much, Your Honors.
the case is submitted. With that, we'll call our last case of the day, 2024 P135, People's Bank versus certain underwriters at Lloyd's, London.
May it please the Court, Your Honor. Chris Riley for the plaintiff appellant. This is a case that involves the application of 231 Section 6C in the context of a property insurance policy. The court, the appellee, and the plaintiff all agree that Sterilite in large measure governs, but have all come to...
So I'm going to jump in here because what I'm not clear about from the briefing is whether, I know obviously there's a statute that governs prejudgment interest, but does the judge have discretion under the statute about how to award prejudgment interest?
I don't believe that they have discretion in the broad sense. I do think it's a balancing of the equities test, but the cases typically tether prejudgment interest to certain facts. So Sterilite, for instance, the triggering event was when legal bills were paid. And the insurer here, Lloyd's, has argued that the fact that it's a liability policy in that case is a distinction without a difference from our property policy in this case. I would suggest that's not the case. Here in the property policy context, what's owed under the policy is the value to repair the property. So here at the time that the proof of loss was submitted by People's Bank on June 4th, 2018, the property had been repaired.
Well, can we, okay, so those are my questions.
So just to finish the thought, though, on my question, what's the best case you have? Is it Sterilite?
I believe it's Sterilite, Your Honor. That's the case that I think describes the rule best. Bank Thermo, which was cited in the judge's decision, also mentions that there is a balancing of the equities trying to prevent a windfall to a plaintiff.
So would you say if somebody was claiming lost profits, that we're going to continue on after the date of, like, say, the complaint was filed, that you would only get prejudgment interest as the lost profits would have occurred?
Yes, Your Honor, I would say that. And I think even in the property context, you know, a basic homeowner's policy, for instance, the way a homeowner's policy works is you have a loss, you're entitled to what's called the actual cash value. So, and then there's a term that says when the building's repaired, you can go back and show that you incurred these additional costs to repair the building and you're entitled to a replacement cost value. That's not what this policy says. What the policy says here is you're entitled to the cost to repair the property, and that's at page 72 in the record appendix. So there's not a clause in the contract that says it's only when you go to the insurer and show, you know, here's my check showing that I spent this amount. What is owed under the contract is the cost to repair the property. The condition that the insurer is relying on is a post-loss condition. So there is the valuation clause.
Slow down, because I think I might have just lost you for a moment there.
Sure.
Earlier, you said, as of 2018, the property had been repaired.
Correct, Your Honor.
Did your client have to pay for it in order to get prejudgment interest?
No, in this case they didn't. What was paid at the time they submitted their proof of loss on June 4th, 2018, was the cost to Crocker, who's the repair contractor. So they had paid $2,200,000.
They had, who's they?
People's Bank had paid.
People's Bank had, well, they were out of pocket.
They were out of pocket.
How was that proved?
There was, well, it's proved because Lloyd's has conceded it in their briefing below.
Where in those stipulations?
In the stipulations, Your Honor.
You're talking about, where you enumerated it in the reply brief where it was in the briefing below?
Correct, Your Honor, yes, where they in the briefing below said that they had been incurred and paid by People's Bank and the way it was working.
And paid when?
prior to the June 4th, 2018
I
filing.
didn't see that in any document that I read.
If I could look at the reply.
And the amount we're talking about is the 2.274, right?
Correct. That's the,
Not what's owed on the one that was still being litigated.
correct, the CRS mitigation invoice.
You're saying, I just want to make sure I understand, you're saying, prior to the time that we made demand in 2018, we, People's Bank, was out of pocket 2.2 million for the repair,
Correct.
correct?
Correct, Your Honor.
And that's in the record where?
So the, I'm looking at the stipulations that the insurer, so for instance, in the lower court, Lloyd stated that People's Bank submitted a sworn statement and proof of loss on or about June 4th, 2018, seeking payment of $2.8 million roughly, an amount that reflects the cost incurred to repair Hubbard Hall plus Historic's alleged contractual liability. And
But see, I didn't read that to say you were out of pocket.
and the next, I think this is at Record Appendix 150 and 151 and page 266. The cost to repair the damage to Hubbard Hall is $2,274,194.07, which reflects the sum actually spent for the repairs, which were completed before People's Bank even filed suit.
Well, okay.
So that's 150 to 151 and page 266.
150 to 151 of the record appendix
Correct, Your Honor.
and page 256.
266.
266.
And, but I think the bigger issue, Your Honor, and this kind of goes to the second part
Well,
about,
before you go to the bigger issue, do you agree with me that under, is it Sterilite, is that the name? Under that case, if you hadn't paid, you don't get your interest.
I don't agree with that, Your Honor, and here's why.
Why not?
Here's why. So Sterilite, the issue in Sterilite, it's a liability policy. And what triggers the insurer's obligation to pay under a liability policy, like was at issue in Sterilite, is when there is a invoice for legal services provided and the insured had to pay out the payment for those legal invoices. This is not that type of policy. And the point I was getting at earlier is there are many property policies where the insured is only entitled to recover what's called recoverable depreciation. So when a loss happens, an insured gets what's called actual cash value. That's owed right away. Then they do the repairs. Then they go to the insurer and say, here's the invoices, here's my canceled checks. Then they get recoverable depreciation. That's not this policy. What this policy says, and it's at page 72 in the record appendix, is the insured or the mortgagee, People's Bank, are entitled to the necessary amount actually spent to repair the property. And there is not a term requiring that they show they spent money or there was invoices paid or anything like that. They're entitled to the necessary amount actually spent to repair the property or the cost to repair the property. So,
But that's not, that's what the policy says with respect to what they're entitled to. But when we're in the realm of trying to figure out what interest you get, Sterilite says you don't get your interest unless you're out of pocket.
well, but I believe it says that because of the policy at issue in Sterilite. I think if you read it, Your Honor, it's saying here they were, let me phrase it this way, Your Honor. Let me phrase it a different way. The only time that the insured in Sterilite is owed money is when those invoices are incurred. So until that invoice comes in the door, that's what triggers the obligation to pay money. Under this policy, the policyholder is entitled to payment of money as soon as there's a loss.
If you go down this road, then he's going to stand up, your opponent, and he's going to say, no, you're not entitled to it under the policy until you meet the loss term.
Correct, Your Honor. And the distinction...
You hadn't met the loss term
Correct,
as
Your
of
Honor.
2018.
Correct.
Your position, you'd met the loss term as of 2018?
No, Your Honor, because that's a post-loss condition. And so the cases we cited, if you look at the M. Di Matteo case, and there's a First Circuit case as well, I'll tell you in a second, I'll get the name. But the issue in those cases was trying to apply a post-loss condition. So you have a policy provides certain coverage. And that's if you have a fire to your house, you're entitled to coverage for this fire. There are post-loss conditions, things like you have to submit to an examination under oath. You have to comply with the subrogation term. And an insurer cannot deny your claim and then require you to follow along with those post-loss conditions. And the loss payment clause that they're citing to is one of those post-loss conditions. So, for instance, an insurer cannot say your claim is denied.
There's a case that says this?
So there is the Insurance Company versus North America, Newtown Manufacturing. That's 187 F. 2nd 675. And M. DiMatteo Construction versus Century Indemnity, 182 F. Sup. 2nd 146. And in those cases, it's not this condition, but it is another post-loss condition, the subrogation condition, that says you have to preserve subrogation rights. And the court said, we're not going to allow the insurer to rely on a post-loss condition after a, quote, unequivocal and never retracted disavowal of liability on the merits. And I would say
so now, in order to decide this case now, we've got to decide that issue.
Well, Your Honor, I think
because I had a different way of thinking about it.
Sure.
Which is, I don't know how they can, if you make a demand and they don't have a good faith basis for disagreeing with the demand, I don't know how they can't just pay you.
Well, and I think that's kind of
Because the clause says upon reaching agreement, right? But they have to reach agreement if they don't have a good faith basis for not agreeing.
And the reason...
Doesn't that take care of the $2.2 million right there?
I believe it does, Your Honor. And I think that kind of plays into why I think this clause doesn't, because they would say, I think, well, we denied liability, and their letter said we didn't necessarily agree with the $2.2 million, although that's the exact figure they agreed to 3 years later.
They have to have a good faith basis for it, which I haven't seen articulated anywhere.
Yep.
If you actually paid.
So you argued that you already spent the money to repair Hubbard Hall before the date of the breach. Does that mean that the prejudgment interest will stay with you and won't be paid to Historic?
No, Your Honor, because I think People's Bank, as the plaintiff who has the judgment, would be entitled to the prejudgment interest. Now,
So the money will stay with People's Bank?
as a legal matter, I don't practically know if People's Bank would pay it to Historic or not, but I think as a legal matter, the interest would be, to the litigant.
On what day did People's Bank pay CRS?
That was, it was after the proof of loss. So my understanding was there was the litigation between Historic and CRS. That was after that wasn't settled till after the judgment in this case. It eventually was settled for, I think, $295,000 and agreed to a $236,000. But I don't have an exact date that
until it was settled, it wasn't paid.
Correct, Your Honor.
Did not pay it.
Correct, Your Honor.
Sometime in 2023.
Correct, Your Honor.
So do you agree that under Safe Light? Now you're going to tell me you don't.
Same argument I made before, Your Honor, and it goes back to
they get interest even though they're not out of pocket.
Because the policy is not a policy that requires them to be out of pocket. What they're entitled to under the policy is the cost to repair the property.
How would your opponents be able to pay you that money until it was resolved?
If they covered the loss, right? If this was a covered loss, then the post-loss loss payment condition would be in place. We could come to an agreement, we could go to appraisal, or we could have a lawsuit on the amount of loss, and we get a judgment. That's how it's resolved practically in these first-party property cases. There are references and appraisals all the time.
I'm not an insurance expert, but you're drawing a distinction then. You're saying that clause about defining loss applies when they agree that they're covering us.
Correct.
We're in disagreement as to the amount. But if they just deny coverage, then that clause disappears.
Correct, and that's the plain...
The cases you cited from federal courts.
Correct, Your Honor. And I'll read the clause itself, the loss payment clause on page 59. Starts off, we will pay or make good any, quote, loss covered under this coverage part. So when they take the position it is not covered under the policy, that clause is plainly inapplicable.
Well, no.
What's the windfall that they're guarding against?
I don't believe there is a windfall. The windfall would be like in Sterilite, for instance. The payment for the legal invoices were not owed until after the suit was filed because the lawyer hadn't billed for that amount. So it was not owed to the insured as indemnity because the defense attorney in the underlying litigation hadn't billed for it. Here, the policy, what they owe when it's covered is the cost to repair the property. Once it's covered, that's what they owe. And if it's a covered loss, you might go through this dispute resolution clause and the loss condition. But
I think your opponent would say the windfall is you're getting interest at 12% on $293,000, whatever that number is, that you have not yet paid. So you're not out of pocket, and you're getting interest at 12% on it from a date earlier than that. He'd say that's a windfall. What do you say to that?
I would say there's nothing, the policy doesn't require me to show the insurer that I spent that money. That's not the grant of coverage under the policy. The grant of coverage under the policy is that amount. And same as a homeowner who has a loss and is entitled to the actual cash value.
Does the judge have discretion, though, to make sure that you don't get a windfall?
I wouldn't call it discretion. I think the judge in Sterilite and Bank Thermo and in all the cases, it's tethered to the facts of the case. So I don't think it is a amorphous, I think this would be a fair result. I think it is trying to prevent a windfall. And so I guess I think they do have some, like there are cases where they say, well, I can't pick the exact date, but I'm going to say the end of the month when these things were bills, and there's a little bit of wiggle room, but I don't think it's I'm going to look at this case as a whole and just come up with what I think is the fair result.
But don't you say that whether or not or whom People's Bank reimburses for such repair work is immaterial?
Yes, Your Honor. Because People's Bank has a claim under the policy, and that claim, if this was a covered claim, there's nothing in the policy that says, People's Bank, have to go to Lloyd's of London and show them, here's my check for $236,000. That's not what...
That's not the windfall that the judge was trying to guard against.
I think it may have been what the judge was trying to guard against. I'm saying that's not a windfall, because that would be owed under the policy.
Do we construe the policy in favor of your client? Like, is there an issue about we construe the policy strictly against the insurance company, or what's the?
It's construed strictly against the insurance company, and that's in the trial court's decision in the lower court. That's what they did.
Right. And Lloyd's argues that you, or certain underwriters at Lloyd's argues that you may not use waiver to rewrite the loss payment condition out of the insurance policy. What do you say to that?
Well, we're not using waiver to rewrite it out of the policy. And again, I'll point to those federal cases I cited.
Okay.
Once there's a material breach of a contract, then the other party doesn't have to comply with the conditions. And again, it wouldn't make sense in the property world. You shouldn't be able to deny a claim and then demand someone come in for an examination under oath, which is another condition. Demand that they produce a bunch of documents. Once you've denied the claim, you can't enforce the post-loss conditions.
Thank you very much, counsel.
Your Honor.
We will hear from your opponent.
Good morning. May it please the court. Bill Schneider for certain underwriters at Lloyd's London. You know, the balancing of the equities, I think, is important to understand exactly what happened here. You had a fire in Northampton. There were two buildings that were damaged. There was Rogers Hall and there was Hubbard Hall. Underwriters paid $5.2 million, which was the policy limit for Rogers Hall. That money went to the bank. The bank restructured its loan with Historic Round Hill Summit, who then took money that was loaned to it from People's Bank in order to fund the repair of Hubbard Hall. There is no information in the record or admissions from the underwriters that People's Bank itself paid directly to the contractors the cost of repairing Hubbard Hall or the cost incurred by CRS.
Well, but what do you say? He's pointing to pages 266 and 150 to 151 that seem to establish that the sum actually spent for repairs was this $2.2 million. Why is he wrong about that?
Well, he's not wrong. So if you look in the record, when I wrote the letter to the bank rejecting its proof of loss. I included a reservation of rights language. You've also got my correspondence in the record appendix at page 325 with Attorney Paul Weinberg, who represented both People's Bank and Historic Round Hill Summit, where we reached an agreement that we were going to table the issue of damages until we litigated coverage. And the fact that this appraisal condition that's tied into the lost payment provision of the policy was suspended, People's Bank actually acknowledged that in its complaint at record appendix page 24.
But I don't think you've answered Judge Henry's question. And we need to have answers to questions, guys, because this is complicated, okay? And I feel like you're both asking us to make law, okay? Her question is, don't you say at 150 to 151 and 266, 2.25 million was paid?
It was.
Used to, and it was paid by Peoples and used to perform the repairs on Hubbard Hall.
It was, like I said, the testimony is in the record. People's Bank did not pay the money. We don't dispute that Historic Round Hill Summit took the money from its restructured loan and used that money to pay for the repair of Hubbard Hall.
So you're saying because this was a restructured loan rather than a direct payment, that somehow has an impact on whether they can get whether Peoples is entitled to receive interest from the date that they had, or from the date that they claimed breach under circumstances where they were out of pocket. You would say, well, they're not out of pocket because it was a loan. Is that your point?
Well, I say they were out of pocket, okay, until such time, all right, we had an agreement as to what the repair costs were. So rather than go through the appraisal process or go through a trial, we negotiated an agreement. The lawyer who represented People's Bank and Historic furnished copies of all the supports behind the numbers, which were reviewed and resulted in that particular stipulation.
They made demand for the entire amount in 2018, and did your client dispute the 2.2 million as of that time?
Well, we did dispute because we didn't have any of the records or information to validate that as the amount of loss.
When did you get the records?
We got those, I want to say, in the late winter, early spring of 2021, leading up to the stipulation that was filed on April 27th.
So that position I understand. So that position is, we don't have to pay the 2.2 million even until we have backup for the 2.2 million. But the reason you didn't get that information is because in breach of the contract, you denied all coverage.
Denied coverage, okay? People's Bank could have, if it wanted to establish that the loss was payable, it could have demanded appraisal under the policy to liquidate its damages.
But you were saying they were not going to cover you at all. So they said, well, maybe we'll take care of that one first.
Absolutely.
That was unreasonable?
I don't think that was unreasonable.
So how can you sort of hide behind that? The consequence of that was that they didn't give you the money, they didn't give you the backup to a demand that they'd made. It turned out to be right, at least for the 2.274, which they'd already paid. They were right about that. How do you get to hide behind that when you're in breach?
So you get to hide behind it because it was the subject of an agreement between counsel. It was expressly referenced in People's Bank's pleadings. And there is no Massachusetts case that I found in my research that talks about a property insurer throwing all of the loss conditions out the window in the event that there's a dispute or it denies coverage. I was unable to find anything directly on point decided by the appeals court of the SJC on that particular issue. In terms of the balance of the equities, where I think it's important to focus here is that you've got the bank, who Judge Agostini characterized as the reluctant warrior, essentially doing the bidding of People's Bank. There's nobody from the bank here today. We've got Mr. Siddall from Historic Round Hill Summit. Wonder why he is interested in the amount of interest that the bank is going to recover. But in the lawsuit that the mitigation contractor CRS...
Does this matter?
It does matter. Because in the lawsuit that CRS filed against Historic took the position that it should pay nothing to CRS because all of its costs were fraudulently and wildly inflated, exaggerated, didn't exist. Its summary judgment memo is in the record appendix.
Again, why does CRS matter? That's the tail.
Well,
that's 200,000 out of 2.5 million.
You've got the same lawyer who's representing Historic saying, no, shouldn't have to pay dime one, representing People's Bank and turning around and saying, yeah, Lloyd's, you should pay $633,000 worth of mitigation expenses to CRS.
Counsel, I mean, what we're trying to determine is when your interest runs, when their interest runs from a judgment they received because you were in breach of contract, right? The plain language of the agreement, the plain language of the statute says from the date of breach. The first breach in this case was in 2018. You said, nope, we're not going to cover you. That was a breach. So you're the one who's arguing for not applying the statute as it's written.
No, I'm arguing it for applying it the way that the SJC did in Sterling.
Right, which is not as it's written. SJC actually 100%, recognize that. We're not going to apply it as it's written. We're going to apply it as in SafeLight. So then we go to SafeLight, and SafeLight says, well, when the money's paid, if you're in breach, well, then they're entitled to the interest from the date they paid the money. And I think we're already established that they paid at least $2.2 million of it back in 2018, and that's when breach was. So why shouldn't you pay interest on it from then?
Because, there was nothing in the record at the time that we argued the motions to prove that People's Bank had paid any amount of money to rebuild Hubbard Hall or to CRS.
So when you use the language, the sum actually spent in 266, what do you mean? You mean by somebody, but not People's Bank?
Well, by Historic, because, they were the ones who were rebuilding Hubbard Hall, not the bank. They were tapping the bank for the construction loan that they had that was renegotiated after the loss and the initial payment of the policy limit. But the judge, in deciding the issue, saw the arguments in writing here and heard us argue about how the bank was essentially tethering a resolution of the amount of loss to whatever Historic's liability was going to be in the underlying case, which dragged this case out for, almost another little over 2 more years. So, I think that the judge in, balancing the equities under the circumstances and rejecting the mechanical application of 231(6)(c didn't find that People's Bank had met its burden to prove that the insurance company had waived the loss payment provision, found that there was an agreement, on a particular date as to what those repair costs were, and calculated prejudgment interest from that date forward.
Do we review the judge's decision for an abuse of discretion, or what's our standard of review?
I believe it's for an abuse of discretion in reviewing. I couldn't find, anything in terms of state law directly on point with respect to the prejudgment interest, but looking at, the motion papers which were presented under Rule 54 in the case law that talks about, how those types of issues are reviewed, it would be an abuse of discretion. That's not to say that if the judge makes a legal conclusion that the court wouldn't be appropriately reviewing that on a de novo basis. But, he says right in his order,
Isn't SafeLight itself an indication that at least some part of this is a legal conclusion that has to be reviewed de novo?
Well, I don't agree because, as short and pithy as it is, the court's decision discusses a balancing of the equities. So,
in that case, the judge below had, as you say, mechanically applied 6C, had interest from the date that coverage was denied, and the court said, nope, that was wrong. And they didn't say he abused his discretion. They said, as a matter of law, the way we're going to read this statute, it has to be from the date the payment was made.
I don't disagree that the construction and the reading of the statute is a question of law.
Right.
But in hearing the parties make arguments about, waiver and estoppel and, the amount of loss, I mean, those were all fact-based issues that the court took into consideration when it balanced the equities and came out with the ruling that it did. And I don't think that on this appeal, People's Bank, has carried its burden to show that there was an abuse of discretion. They're advocating for the mechanical application of the statute. Oh, Judge Agostini found a breach on this particular date, so we've got to start the interest clock running on that particular
If that were
date.
their argument, they'd be wrong.
I think they are.
They have to show that they made a payment under Safe Flight. If they didn't make, now, I say they'd be wrong. Now, your opponent would say, no, you're missing the point. It's a different kind of contract, and under that contract, actually, the obligation accrued and actually existed earlier. Oh, okay.
So, yeah, so, I mean, the way that I have approached this was, we have a trial judge who heard 54B motion, considered the arguments of counsel, considered the written papers and the exhibits presented, the same stuff that's in the record before you, although there's no transcript of the hearing. I don't think anything happened at the hearing that would move the needle on this one way or the other. But he applied prejudgment interest from the date of the agreement. I think in order
Were
to...
both parties seeking the entry of a 54B judgment?
I did seek the entry of a 54B judgment, and my motion was denied because...
What was People's position on that?
That's when Peoples made it clear that they wanted their case, the damages in their case, tethered to Historic's potential liability to CRS. And, that pleading, it's not in the record, but it's certainly part of the public record. I mean, there were claims for breach of contract, interest,
Why wasn't
penalties,
that
attorney's
entirely
fees.
reasonable? They wanted to be paid for the full amount of the insurance, which wasn't just the 2.2, but it also included whatever they agreed to pay to CRS.
It's 100% unreasonable when you have the same lawyer representing People's Bank and representing Historic, who's arguing in the Historic case that CRS should be paid nothing because their billing is fraudulent.
Well, they
and
make whatever
exaggerated.
argument they want, but they lost.
And then, no, they settled the case.
Right, for $200 and something thousand, which
settled it.
your client had insured.
They settled it for more than what we finally stipulated to be the fair and reasonable mitigation expense.
Again, I don't see the relevance of that. Your client had agreed to insure at least the amount that was paid.
The relevance is that the bank is tethering its customers' liability to a mitigation contractor to its own claim. And by using the same lawyer to argue contradictory positions, I think that plays into the balancing of the equities. So I think the trial judge, he got it mostly right. There's some little nuances about, whether the loss was payable 30 days after the stipulation. But, the underwriters didn't bother raising any of that. I mean, they've paid the judgment, they've paid the interest. The only thing that's live in the case is this dispute.
So you're saying if a 54B separate judgment had entered on the 2.2 million, your client would have paid it at that time?
Oh, absolutely.
Do you agree that if your client had no basis to disagree with the amount that had been claimed, then your obligation was to pay that at that time under the loss provision?
If there was an agreement, okay? Now I know we're splitting hairs. I know you said disagreement.
Well, but I said it for a reason, and it's this: you have an obligation of good faith and fair dealing.
Right.
Okay. So if they say you owe us 2.8 and you agree 2.2 of that is owed, we don't agree with the next 600, but 2.2 of that is owed, don't you then have an obligation to reach agreement as to the 2.2 at that time?
If there's no support for it, I mean, if all the support...
If it's supported and you agree.
If it's supported and there's an agreement, yes.
No, I'm sorry, I shouldn't have said and you would agree. If it's supported, don't you have to agree for purposes of your contract? You can't at that point say, well, it's true that we owe 2.2, but since we're disputing the other 600 grand, we're going to hang on to the whole thing for another 3 years.
Listen, I didn't think that the loss was liquidated at that time. There was the agreement. We tried to get the final judgment, and People's Bank pushed back and said, we want Historic's liability to the mitigation contractor rolled in there.
But you could have, at the point you didn't get the 54B judgment, you could have still paid the $2.2 million.
I mean, theoretically, perhaps, but
Not theoretically, under the obligation of good faith and fair dealing that inures in every contract, and specifically by statute to insurance companies.
all right, well, see my time is up. Thank you very much.
Any other questions? You good? Thank you. That'll conclude our session today. The case is submitted. I want to thank all of our court staff for their assistance in making this happen.